There it is. Hold on. Okay. All right. You got it. You got it. You got it. Cover up the speaker. Okay, the 11? Yeah, can you call my services? Yeah, okay. I'm sorry, I'll let you finish right now. I'm sorry. Try it? Oh, good. Excellent.
Do we have some of the wipes? No, maybe it's. Well, I'll get it. That's right. That's right. Let me make a phone call. Yes, Steve. Hey, did you have some of those beats? Make a call. All right. Chris, you about ready? Okay. Okay, all right. Good morning, councils, interested parties. We're back on the record in the matter of the state of Georgia versus Khalif Adams et al. In 22 SC 183572. All right. Mr. Stillwell, Mr. Botts, and Mr. Sharp. Good morning, gentlemen. All right, Mr. Williams, Mr. Steele, Mr. Adams, and Ms. Renard. Good morning, councils. All right, Mr. Kendrick and Mr. Weinstein. Good morning. Mr. Huey and Mr. Matthews Jr. and Sr. Good morning, gentlemen. All right, Mr. Nichols, Mr. Harvey, Ms. Westmoreland, and is Mr. Garner here? Okay, all right. Well, good morning, councils. And Mr. Ryan and Misty Williams, good morning. All right. Ms. Love, Mr. Smith, Ms. Hilton, and Mr. Atkins, good morning.
Good morning, Your Honor.
All right.
Mr. Brown is back there.
Say again?
Mr. Brown is with today.
Okay, all right. Mr. Brown, oh, he's in the common seats. Okay, so, you know, we have a cutoff. Mr. Brown, good morning, sir, as usual. All right, okay. We left off last Tuesday. We were talking about States 14 uniform, the video. So, Mr. Sharp, Ms. Love, have we made all the corrections, and Ms. Steele, this applies to you as well, sir. Have we made all the agreed upon, I guess, changes to the video so they can be shown?
Your Honor, we did make changes as the court requested and defense counsel requested. I sent the copy of the video with those changes to counsels for each of the defendants. Prior to the weekend, I heard from Mr. Sharp requesting that an additional extraction be made. I made that change and sent that to counsel.
I commented on that, and I suggested you do that. Has there been any other conversation since that last query from Mr. Sharp?
Except that I sent the video out with those changes.
I did see that yesterday, yesterday.
And since that time, I've gotten no other requests. So
Okay.
all of those changes were made.
All right, Mr. Sharp?
Yes, Your Honor. I did check behind the state's work, and they did make that additional change, so I can confirm that. I just want to reiterate on behalf of Mr. Stillwell and I believe other defendants as well, we are still objecting in total to the playing of the video for the reasons enunciated last time we were in court, but I can confirm that those changes have been made as requested.
Are you going to play the video, or are you going to use it to, for lack of a better word, impeach Mr. Stevens?
Your Honor, we would be playing the video. With those changes, we'd be starting at 1:58, 1 minute and 58 seconds in. So in total, it should be a 20-minute display for the jury.
Okay, all right. Other than the objections that were made by Mr. Steele and Mr. Shard, are there any further comments about State's 14 uniform? Yes, Mr. Steele.
Morning, Your Honor.
Morning.
Good morning, everyone. Good to see everybody. Your Honor, I understand what Mr. Shart said. I'll adopt it, but I believe that Mr. Stevens can be impeached with the sliver of, did he have enough time to speak with his counsel? So I know Mr. Shart's objecting to everything. I believe that that's proper impeachment, but everything else that is being played is over Mr. Williams' objection for improper bolstering.
Okay, all right. Anything further from the State?
Just to reiterate the response that we gave last week, which was the entire purpose for the jury needing to see the interaction with and the responses of Mr. Stevens during the plea colloquy. We are playing it for the.
I don't think it would be a bolster from Mr. Steele. Given Mr. Stevens' testimony in total, it would come in for that particular purpose. I mean, I would agree with you otherwise, but he's been sufficiently examined, or I think the legal term would be attacked. So I think that the State's well within their purview to do that at this time.
Okay.
But I'll note that over your objection.
I understand.
Okay.
Can I just approach Mr. Kearns?
Yes.
And Your Honor, at
Madam.
the time that the court permits me to do so, there is one housekeeping matter that I would like to address prior to the jury being brought out at the appropriate time.
You can do it now because we're done.
Thank you, Judge. As it relates to an objection that has been made previously regarding leading questions, with the court's permission, I'd like to simply give some case law on that.
Okay. Who are you trying to lead to begin with?
I'm not trying to lead anyone, but sometimes I've asked questions and objections as to leading have been made, and I think I sent this to counsel for the defendants and Mr. Kearns some time ago, but if I may just bring it to the court's attention.
I take those up on a case-by-case basis because I'm familiar with not all the case law, but some of the case law. It depends upon the circumstances. So you want to wait until that time and then further elucidate me as to that particular issue, or because it really does depend upon what and how the leading may be, may come up.
Most certainly. And if the court will allow me, because I don't want to at all bring up cases, if the court will allow me upon an objection being made as to leading to just approach with the case law so that I can address it at the bench.
How long is, because I think that it's situational. I mean, so it really wouldn't be helpful to me at this point. I'm not to say that no law is not helpful to a trial judge, but if, it might be more helpful depending upon the circumstance. So.
Okay.
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 Anything else?
Generally, it's as to yes or no questions. I've noticed that those are the ones that get the most objections as to leading when we make an inquiry into a single fact. Did you go to the store at the end? There's been that objection as to leading, but Vernon versus the state and others that I've given to Mr. Kearns say that an inquiry into a single fact is not leading. If I say, if you went to the store at the end, didn't you? That is.
That's leading.
So that's it, and thank you for allowing me.
You're welcome, madam. Okay. Anybody else have anything else before we bring in our jury? Okay. All right. Sergeant Ham, I've promoted you. See that? Look at that already. All right. Congratulations. Sir, good morning, sir. Our jurors all here?
Yes, sir.
Okay. All right. Can you bring them out, please?
Can we have Mr. Stevens?
Yeah, can we bring out Mr. Stevens, please? Have him come in again.
You want me to come in first?
Yeah, let him come in first. Okay, why am I getting that? Summarize yours, please, sir. Thank you, sir. One. Are we up and running still? Or in and out otherwise? Okay. Okay. You can tell him that I really like him. Ladies and gentlemen, be seated for just a second. I think we have a delay, so. Okay, all right, no problem. Okay. Oh, okay. Mr. Steele, you good?
Yes, sir.
Okay. Okay.
When the court has time, I bring up matters if there's time.
Do I need to excuse Mr. Stevens?
Not on my behalf.
Okay.
If it relates to what is.
Mr. Stevens, can you step outside the vestibule just a second, if you wouldn't mind? Appreciate it, sir. Yes, yes, sir.
Just to put this on your court's radar, I just wanted to, I thought maybe there was a little time here. There's a few things. I received this past week, and I don't remember the date, but it's electronic. I could tell you if you're interested. From the prosecution, specifically the Honorable Mr. Brown, and he sent a DNA report and a DNA witness. It deals with Act 5, 6, and 7, over at Act 5, 6, and 7. It deals with Adrian Bean, B-E-A-N. Mr. Williams is not charged in that act. We will be objecting to any mention of Mr. Williams. But this DNA expert is not on the state's witness list. The 700 plus witnesses, nor what the court ordered to pare down. And I never received, nor did anyone else to my knowledge, if I'm wrong, please correct me, the DNA report of this expert. So I've never consulted with a DNA expert because of that. So I'm moving to exclude any DNA mention and the report and the witness. That's one thing. And then I gave Your Honorable Court co-worker, the Honorable Mr. Kearns, just a printout. You already ordered this, Your Honor. It was dated November 17, 2023. But all experts, it's in the second paragraph, it's a one-page order, all experts' reports, analysis, findings, and the basis for same must be provided to counsel for each person in stanter. And you cite Harris versus State, which is 314 Georgia, 238, it's in Division 6A, as in Elisa Alpha 2022. And it says then, if these orders are not complied with, this Honorable Court will entertain any and all lawful sanctions. So that is my one issue, if there's time for that. A second issue, and it's related, is the state gave us what I'll call tweets. I know it's called X now, but tweets that supposedly Detective Belknap will use, and they're from Mr. Williams, I believe, Twitter account. I'm not opposing that. I don't need a foundation to be laid as long as the state has a good faith belief that these are what they say they are. I'm okay with it, but they're pulled out of context. They're just, like one symbol. So unless there's a foundation laid, or I guess a stipulation, because I don't really need to sit here and watch a foundation be laid, but a stipulation that all relevant, though, tweets are admissible, that's fine. But most of these are character. They're just, what's up, my homies of blood, what's up, blood, I love SMM, and things like that. So that is my second issue. And then finally, Your Honor, I've noticed like a theme that I'm being mentioned a lot, along with the Honorable Keith Adams. Did, Mr. Stevens speak with us? Did he do anything? Did I go visit him at the jail? I have no memory of visiting Mr. Stevens at the jail, but I'm not saying it's not true, because I assume the state has a good faith belief that I did. But if I did go to see him, I did not do anything inappropriate. And I did not see him recently. And I know the state didn't say I did anything appropriate, but it's just this constant, like, Mr. Steele, did he ever come to see you at the jail? There's nothing wrong with seeing a person at the jail if it's true what Mr. Stevens said. And again, I don't have a memory of this. And I looked at my diary. I don't have it on my diary. But I don't have a year. I just don't know when this supposedly occurred. But he has a probation revocation case. And you ordered that any time that I'm going to be mentioned, or I'm now including Mr. Adams, the state has to bring it to your attention, why it's relevant, and outside the presence of the jury. And I don't think that was going on. From opening statement, where I had to ask for a mistrial because my name is there representing someone who's not even here, to consistent with Mr. Stevens. So that's my third issue. And I think I said finally, but the last one is I'll be objecting. There's a movie theater incident. A person, it might have been two people actually, who was shot at a movie theater. Mr. Williams was at the movie theater. He's one of the celebrities there. People came out to see him, and a lot of celebrities were there. There was a premiere of a movie. I don't have any evidence that Mr. Williams shot anybody, asked anybody to shoot somebody, was a participant, was a party to the crime. So I'll be objecting to that. And the state just gave me additional discovery on that movie theater incident that I never had before, and that was done. And I listened to it and I watched it. And I'm not complaining. You know, I'll absorb all the information. I don't want the state to say, you know, as we roll this case, why didn't you tell me earlier you're objecting? So I thought you had a few minutes, and I just want to bring all of those to your attention to flag them. And that's, you know, that's
So
generally
four
what
issues? Okay.
those are generally what I'm just
All right.
asking you to keep on your radar. And if you want to address any of them, I'm more than willing to.
All right, let me see what the state's response is to. So let's deal with number one, the DNA issue in terms of overt acts 5, 6, and 7. Was there a report produced, madam, and if so, when?
Your Honor, there was, and I would ask that the court allow us to, I don't know how much time we have, but number one, we're not introducing that act or evidence of it today. I believe that that would be a matter we can take up at the end of today. Regarding
Still didn't answer my question. You all
it
are really,
was. I'm
y'all are
sorry.
really good about that. So my question was kind of clear. Did you get a report, and when did you get it?
I do know that we served in preparation for this week coming up. We did notify Mr. Steele that there was a report. I have to look back through records to see when we got the report and when and if it was actually turned over as part of discovery. Judge, I can say that, of course, there's nothing inadvertent left out. What the report is a report from a DNA specialist who says that because of the mixture of the DNA on the guns that were tested, they were not able to extract or to develop a profile from any one person because it was too mixed up. So
Okay.
we have additional arguments, and we would like the opportunity to make certain that I have no reason to believe Mr. Steele is misrepresenting anything to the court regarding whether or not he received it previously. We'd like to confirm that.
Let me know and give me the date of when you received it,
Okay.
and when you turned it over.
Okay.
All right. And when's this witness going to be called?
What date do we have? Next Thursday, maybe?
Next Thursday?
Yes,
All right, so we
Judge.
can defer until that time, or close to that time. All right, so that's issue one. Issue two is these tweets, and this is the Detective Belknap.
And Your Honor, again, this is a subject that will be better served being hashed out in an argument after court today, perhaps, because it will be a little bit lengthy. But generally, our contention is that Mr. Steele is free to introduce any part of his client's tweets that he wants to. He cannot, however, dictate which portions the state chooses to put in, and he is entitled to introduce the rest of every one of the pages that the tweets come on. We do not have to. There's no law that suggests otherwise.
That's a rule of completeness. So.
Right, he's allowed to.
So when cross-examination occurs, unless there's some other basis to cross, or those tweets are objectionable, then I'll deal with them as that case, as the matter comes up.
And to be clear, the state has absolutely no objection to Mr. Steele completing the record with his additional tweets as he
That would be
sees
his
fit.
right anyway, so to ask or
Okay.
to. So that's two. Number three is the mentioning of Mr. Steele and Mr. Adams. I get to in regards to Mr. Stevens. Is that to show bias or?
Absolutely, and
All right. Okay, or attempted bias.
yes.
All right, okay. And anything else in regards to that?
In regards to that, yes, it was fresh on the state's mind, this prosecutor's mind, when I stood up to introduce or to speak with or examine Mr. Stevens in front of the jury on one particular day, because Mr. Stevens was very adamant that he did not want to speak with any member of the state. And as we walked past, he was huddling with Mr. Adams and Mr. Steele. So and not only that, but we have the records from when Mr. Steele visited Mr. Stevens at
So you
the
had a
jail.
good faith basis to ask that question?
Yes, Your
Okay,
Honor.
all right. Number four is the movie theater incident, the premiere. When is that going to,
What day?
testimony of that?
Mid-February, Your Honor, is when we are planning to introduce evidence of that. So I think that that's another matter that we can take up after we have completed at least this day's worth of testimony to allow us to be
Okay,
expeditious about our time.
all right. So I'll defer on that until we get a little closer to that.
Yes, Your Honor.
All right,
Thank you.
okay.
make certain to get that to you today. Absolutely. But I have to do it after court. Is that okay? It's in Odyssey. And if Odyssey, I'll pull it up for you.
You almost ready?
Hey, Brad.
Okay, all right, yeah, let's go ahead and summon our jurors, please. Yeah, thank you. Can we bring in Brown, bring in Mr. Stevens, please? Thank you, sir.
All right, for the jury.
All right, thank you, Deputy Ham. Ladies and gentlemen, please be seated. Members of the jury, good morning. Good morning. All right, let's address the elephant in the room. Why'd you get such an extended break? Well, yours truly fell ill. So it happens. And it happened very suddenly on Tuesday right after court. So my admonition to you or suggestion to you about staying healthy and everything else, we've had an uptick in whatever is going around Atlanta, you name it. So to that effect, I've ordered that the courtroom be sanitized, your headquarters be sanitized. But remember what I told you last week about just the whole thing of just making sure your flu shots are up to date. You've had the updated COVID booster. You hand wash, you use sanitizer. Make sure you take care of all those precautions because I got to account for all of you. So it'll just help us and our advocates the same thing. I've told them the same thing as well. But unless there's anything else, ladies and gentlemen, we're going to go ahead and continue with the presentation of the state's case at this point in time. Mr. Stevens, I'm still under oath, okay? All right, Madam, Ms. Lowe.
Mr. Stevens, I have 3 more lines of inquiry for you and we'll be done, all right? Okay. Mr. Stevens, on cross-examination, I'm going to show you what has already been admitted as Defendant Williams Exhibit number 4. And ask you if you recall seeing that and speaking about Defendant Williams Exhibit number 4 on cross-examination with Mr. Brian Steele. You can look through it.
Yeah.
Okay. And Defendant Williams Exhibit number 4, would you, is it a 21-page document going from page 1698 to page 1718 of an Instagram business record?
Yeah.
All right. Did you read all of this document for the jury or just parts of it that Mr. Steele asked you to read?
I didn't read all of it. I didn't read all of it.
All right. Now, when you were reading various lines, do you recall reading the line that my finger is pointing to on page 1700?
Yes.
Okay. Keep talking about joke. This ain't no joke. Y'all niggas ain't worth enough to cover a $1,500 rent. What's funny? Is that you talking?
Yes.
Who is real1_FR?
Darius.
Darius Ford.
Yes.
Your friend who was murdered.
Yes.
And does real1_FR say, I know what I'll pay or do so I can play?
Yes.
All right. And when you're talking about the rent, are you talking about the rent at the web?
Yes.
All right. And do you at one point during this text thread say, y'all know I paid last month rent by myself. Here goes something right here, slug. I know what you did. Did you say that in part of the conversation?
Yes.
All right. And were you living at the web? Is that where you were living, or were you living with your grandmother?
I was living with my grandmother.
All right. But you were paying the rent at the web
Yes.
along with other people?
Yeah.
Other YSL members?
Yes.
All right. Do you recall saying in the same text thread, or rather in the same text thread, I've been paid the rent? Do you remember saying that, or do you need to see it?
I need to see it. Yeah.
All right. And Slime Life Shawty, who is that?
One.
Winnie Lee?
Yeah.
And he also is a member of YSL or Young Slime Life?
Yes.
And did Winnie Lee in response ask, how many niggas be sleeping there? You want to see it?
I mean,
Sure. I'll just sit right
yeah.
here. And did he ask you to give a number?
Yes.
4K Tay having his way. Who is that?
I don't know their real name for
All right. Did he respond, it's an easy $100 a piece?
Yes.
And was that in response to your saying you needed $1,500 for the rent? Here, you can go back.
What?
Go ahead, take it.
I don't know.
Okay.
I don't know what is this in response to.
No problem. Did you then say, ain't nobody working, everybody got their own motion, find your purpose to the game?
Yes.
Did real1_for_real or _FR say 6 niggas sleep here?
Yeah.
Was he talking about at the web?
Yes.
And does 4K Tay having his way say then, that's 600 right there?
Yes.
And 12 if y'all go 200.
Yeah.
Did you then respond, the gang, shawty, you know how it be.
Let me take up you guys.
Sure.
No.
Or did real1_for_real say the gang, shawty, you know how it be?
Yes.
Okay. And did 4K Tay having his way say 40 a day, 1,200 a month?
Yes.
All right. After that conversation, and if you need to go ahead and read through it, you can, because I'm going from page 1703 to 1704 to 1705.
Just ask the court, it's okay if this legislation announces instead of the page, but also the time.
Your Honor, Mr. Steele it's his exhibit. I'm just reading from defense exhibit number 4.
Just announce the time, please, madam. It'll help everybody kind of orient us to time and space.
Yes.
Okay?
Yes, Your
All
Honor.
right, thank you.
On page 1706, after that conversation and as part of that conversation about the rent, you see on 1703, where you say on February the 6th, 2021, as according to this document, I've been paid the rent. And then on page 1706, at February the 7th, 2021, on this document at 1 o'clock in the morning, you have Thugger 1 saying, y'all just start bringing me the money, really?
Yes.
And does Slime Life Shorty, do you ask, does Slime Life Shorty say gonna be no more company at the Yo after that request?
Yes.
And does Thugger 1 say, y'all heard me clearly, sir?
Yes.
And then does he say, man, y'all little niggas stop playing with me?
Yes.
And did 4K Tay having his way say, that's all I be saying, Slime?
Yes.
In response to Thugger 1 saying, man, y'all little niggas stop playing with me?
Yes.
And does 4K Tay having his way then say, I don't care who mad at me?
Yes.
Does Thugger 1 then say, I step FR, meaning for real, for real?
Yes.
Okay. Does 4K Tay having his way then say, they know?
Yes.
And do you respond, I don't get mad, 4K, I get money?
Yes.
Does the conversation proceed from that point, I don't get mad, 4K, I get money? 3 lines or 4 lines or more down to where Thugger 1 on February the 7th, 2021 at 1:07:38 UTC on this document say, y'all niggas stop saying sucker shit then. I hear all of it, and today I just want to let y'all know. Does he say that?
Yeah.
In response, do you say, I asked about the rent money. That's some sucker stuff. Won't ask about it no more.
Yeah.
And do you say that after Thugger 1 says, y'all niggas stop saying sucker shit then? I hear all of it, and today I just want to let y'all know.
Yeah.
All right? And after you say, I asked about the rent money, that's some sucker stuff, won't ask about it no more, does Thugger 1 say, everybody in this text, because everybody, y'all done got something from me. All that little lame ass shit niggas be saying can go far. Does he say that?
Yeah.
And then does Thugger 1 tell you, slug, relax? It's not about no fucking rent money.
Yes.
And does Slime Life Shorty respond that part?
Yeah.
Does Thugger 1 respond on February the 7th, 2021, according to this document, 1:09:44 UTC, niggas just be saying little lame shit behind the nigga back and begging when we meet?
Yeah.
Do you respond, speak highly of you in any circumstance, any situation, on February the 7th, 2021?
Yeah.
And then does Thugger 1 respond, right, so what are you talking about then?
Yes.
Do you then say understood?
Yeah.
Does 4K Tay having his way say got your back, behind your back, and niggas say I'm sick riding, so be it?
Yeah.
And does Thugger 1 then say, on like that sucker shit, niggas getting too crazy thinking they can say that to me on a text? I'm a gangster for sure, for sure. Does Thugger 1 on February the 7th, 2021 at 1:12:21 UTC say that in response to 4K Tay having his way?
Yeah.
All right. Does Slime Life Shorty respond, you talking about what I said, Slap?
Yes.
And then does he say, you took it wrong, Slime?
Yes.
And does Thugger 1 then say, y'all niggas lame AF? Does that mean as fuck?
Yes.
Okay. And stop asking me for shit, because I ain't lame and I can keep all mine. Does he say that?
Yeah.
Does Thugger 1 then say, I'm talking about all y'all, not just you?
Yeah.
Does he then, in capital letters, write everybody?
Yeah.
And then does he then say, nigga, you know you can come to the studio whenever you fucking want, so why would you ever say that?
Yeah.
And later on, does Thugger 1, after saying, I shouldn't have to take nothing wrong, it don't say, you don't say it knowing it ain't for you. And then does he say, y'all remember I'm on the chat too, bro. Keep all that lame shit on the other one.
Yeah.
Does he then say everybody?
Yes.
Does Slime Life Shorty then say, y'all niggas start kicking in? It shouldn't be no 1 or 2 niggas paying for everything that everyone use. Everybody do their part, so we won't have these problems, gang. Can we all do that? Does Slime Life Shorty say that?
Yeah.
Does Thugger 1 then say, this shit ain't about no money, twin. I pay for everything for niggas. Does he say that?
Yeah.
And does Thugger 1 on 2/7/2021 at 1:19:51 UTC say, it ain't about that?
Yes.
And then do you in response say, only thing I was saying is I can't afford to take care of this family by choice. Not yet anyway, when the only thing I make is $400 off each one. I pay $1,500, that will hurt.
Yeah.
All right? Do you then say, after a few attachments are sent, I know you ain't getting no disrespect from me. I won't disrespect nobody. That's part of the reason I stopped cussing, so I won't disrespect nobody. I don't want to feel it either.
Yeah.
All right. And does Thugger 1 send a series of attachments after that point?
Yes.
All right. Now, on redirect examination by me before we last were in court, did you tell the jury that the defendant Williams wrote a song called Dropping Jewels?
Yes.
And is that still your testimony that defendant Williams wrote a song called Dropping Jewels?
Yes.
Do you know who Chandler Durham is?
No.
All right. Did you tell the jury that Dropping Jewels was about the defendant Williams being truly humble under God?
Yes.
All right. And the line that you referred to, was that line that ain't no more reminiscing, ain't no more judging, no intuition line?
No.
Which line was it?
You asked me name a part in the song where he was referring to God, and I said the first line in the song, to show me why I'm living, why I'm remaining here.
Okay, thank you for that. Prior to that line of questioning, did I specifically ask you how many songs did the defendant Williams write about being truly humble under God?
Yes.
And did you name this song as one of those songs?
Yes.
And when I asked you where in the song was he talking about being truly humble under God, is that when you said, tell me why I'm living, why am I remaining here?
I thought your question was to show me where in the song that he was referring to God, and that's what I gave you.
Okay. Is the line, I was smoking Scotty but not Pippin, I taught my son how to stack that shit to the ceiling, also a part of Dropping Jewels?
Yes.
It's drop a body and you wouldn't have to pay for lunch. I told my dog I'm riding, whether he right or wrong. I done got big, they record my life through a drone. I told my bitch to stay behind me, I'm in my zone. She like, how the fuck you ain't never wrote a song? You riding for life, then I just rather die alone. Bought you a spot, now you don't, never gotta go. Yeah, I told my niggas I'm dropping the jewels on him. You gotta go through that shit with your heart, you can't snooze on it. Are those also words in the song Dropping Jewels?
Yes.
All right. Is there any part of what I just read that refers to the defendant Williams being truly humble under God?
Objection calls for speculation.
I'm going to overrule the objection.
You may answer it.
You said, do what you just read talk about God? No.
Okay. Is the line, you gotta go through this shit with your heart. You can't snooze on it. It's bad. You better get rid of it or lose on it. I know you heard that old saying about bad fruit, homie. If you can't beat them, knock them out. If you're gonna kill them, better not be sloppy. Are those lines in Dropping Jewels?
Yes.
In Dropping Jewels, does Defendant Williams say, I told my daughter keep one in the head, she ain't gotta cock it. I told my son if he wanted to live, he might catch a body. I told my son he ain't a cheerleader, but he might gotta catch a body. His driver named Joe, but he still can't do it sloppy. Are those all lines in Dropping Jewels as well?
Yes.
Do either one of those lines refer to the defendant being truly humble under God?
Objection calls for speculation.
Overruled.
No.
All right. Do the lines, I just hopped up out that ghost, I've been driving a dead body, I ain't really into nothing, but I spend it like a hobby. I was locked inside the trap, didn't think about it, but I got outed. Now my cars and clothes exotic. Ain't 6'9", but 2 hoes with me right now. You can call me Shawty. I've been dropping all my Vicks, and now the FBI won't stop me. Are those all lines in Dropping Jewels?
Yes.
Do either of those lines refer to the defendant being truly humble under God?
No.
Right. Got this shit on fire like Takis, nigga. Whoa, whoa, whoa. Ain't no more reminiscing. Ain't no more judging. No intuition. Tell me why I'm living. Why am I remaining here? Are all of those lines in Dropping Jewels?
Yes.
And besides the tell me why I'm living, why am I remaining here? In your words, do any of those lines refer to the defendant being truly humble under God?
No.
I told my bitch I was about to go shoot up Trestle Tree. $500,000 on my dogs and all my cars. Couple millions to my mama and my pop. Got the sniper on the roof for niggas trying to act hard. I just bought a brand new coupe and it's a black Jaguar. Matte black, old Trans Am, thank you ma'am. We gonna make us a porn star video, new cam. I came up just watching, my pop gamble my food stamps. I just cause cramps, I don't go back and forth with tramps. Baby, we stamped. Just for that, I'ma call you ma'am. Got the T-Rex, I just gave my daddy the cam. I got the sheets wet, hit that little bitch up, then I slam her like I'm from BX. Then I fold her up like a clam, yeah. It was dark, then I came to the light. I was poor, and now my door's suicide. I don't know how to make it right. Bought 4 Birkins for you, keep it light. I don't care about you leaving me. I got no time to try to make it right. Are all of those lines from Dropping Jewels?
Yes.
Do any of those lines, to your knowledge, talk about the defendant being truly humble under God?
Objection calls for speculation.
Overruled.
Not to my knowledge.
Okay. Did you testify on cross-examination with Mr. Brian Steele to the following 2 facts or 2 assertions by Mr. Steele? That after Mr. Jeffrey Williams became famous, you 2 went your separate ways, and that the defendant Williams bragged or took credit in his songs for acts that you committed.
Yes.
Would you tell the jury what acts defendant Williams took credit for in his songs that you committed?
I don't think he was just saying specifically. I think he was just saying, like, how I was living at the time. I was selling drugs and carrying guns.
Did you testify to this jury that you were jealous of the defendant Williams because he, by taking credit for acts that you did in his songs, was making money, rapping about things that you could have been making money from?
Yes.
And general acts of selling money and carrying guns?
Yeah.
Okay, so no specific acts.
No, ain't nothing specific.
Were there any specific acts?
All right, that's a standing objection. That's the fact.
No, nothing specific.
So what kept you from rapping about it yourself?
I ain't have a talent.
Your Honor, at this time, the state asked permission from the court to publish State's Exhibit 14 uniform.
Any further objections other than the ones that have been made? And I'll note that 14U will be I'll admit 14 uniform and it'll be published as you see fit. And note that it will be a continuing objection.
Thank you. You got me, Susan. And Your Honor, for the sake of brevity, we're just gonna push it forward to 1 minute and 59 seconds.
All right. Yeah, if you would make sure that you put the time hacks on for the purpose of the record.
And Your Honor, this is going to be a 20-minute exhibit, and after this, the state has no further questions.
Okay. Ladies and gentlemen, you good?
Mr. Stevens, if you could please state your true and correct legal name.
Trontavia Stevens.
And are you the same person referred to as Trontavia Stevens, also known as Tick and also known as Slug, on indictment 22 SC 183572?
Yes.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you?
29.
And how far have you gone in school?
I got a GED.
Okay. Are you able to read, write, and understand the English language?
Yes.
Do you understand that you are charged in this indictment with count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, your attorney Gladden, about all the facts and circumstances known to you regarding the charge in this indictment?
Yes.
Have you also been able to speak with her about any potential defenses?
Yes.
Do you need any more time to discuss this matter with your attorney?
No.
Are you satisfied with her counsel and representation?
Yes.
Do you waive formal reading of the indictment?
Excuse me?
So waived.
Yes. I asked if you and your attorney waive formal reading of the indictment.
That means they don't want to read the charge.
If not, I got to read the indictment.
Yeah, so waived.
Okay? All right.
Do you waive any and all defects, if any, with respect to the indictment?
Yes.
Mr. Stevens, have you been arrested on these charges?
You've been arrested on these charges.
Yes.
Okay. And Your Honor, the state is unaware of any outstanding warrants related to these charges. Ms. Gladden, are you aware of any outstanding warrants as it relates to these charges?
I'm not.
Okay. Has your attorney advised you of the minimum and maximum sentence for the charge in which you are pleading to?
Yes.
Do you understand this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence that I will read, but the court does not have to accept this recommendation, and that the court can sentence you to the maximum on each charge?
Yes.
Do you understand that?
Yes.
Do you understand that this plea, the state's offer on this plea is, as to count 1, 10 years to serve 2 years, commute to time served with a balance of 8 years on probation? Do you understand that?
Yes.
Do you understand there are certain special conditions as it relates to this negotiation?
Yes.
For one, you shall abide in full by each and all of the terms of this negotiated agreement, and your failure to abide by any of the terms of the agreement shall constitute a violation of this agreement. Do you understand that?
Yes.
Do you understand that you shall testify truthfully about all matters relating to this case upon which you are questioned at any trial or judicial proceeding stemming from the facts alleged in this indictment?
Yes.
Do you understand that in accordance with testifying truthfully about all matters related to this case, you acknowledge that each and all the statements contained within the defendant's factual acknowledgments portion of this agreement are true, and that you will testify truthfully about those statements and any matters related to this case when asked to do so?
Yes.
Do you understand as a special condition, you shall possess no guns unless your right to do so is restored?
Yes.
That you should also submit to random drug screens by the Department of Community Supervision and any agency designated by this court.
Yes.
That you shall commit no criminal acts.
Yes.
And that you will relinquish any Fifth Amendment right related to any statement contained within the defendant's factual acknowledgments contained within this plea agreement, and you will make no attempt at trial to assert a Fifth Amendment privilege when questioned on these matters. Do you understand that?
Yes.
Do you understand that some of the factual acknowledgments that you acknowledge is one, that Young Slime Life, aka YSL, is an organization made up of 3 or more members or associates who share common identifiers that include but are not limited to colors, hand signals, and terminology, who have committed crimes intended to increase the notoriety, street credibility, and reputation of YSL. Is that one of your acknowledgments?
Yes.
Do you also acknowledge that you were one of the founding members of Young Slime Life?
Yes.
Do you also acknowledge that you committed an aggravated assault as alleged in count 1 of this indictment by brandishing a gun at an undercover police officer that was surveilling a vehicle that was hijacked from a woman?
Yes.
Do you acknowledge that in October of 2014, you were arrested with a red bandana and you were observed with a YSL tattoo and a Cleveland Avenue Rock Crew tattoo, amongst other tattoos?
Yes.
Do you also acknowledge in that same incident, when you were asked by law enforcement about your Rock Crew and your YSL tattoos, that you truthfully advised law enforcement that you were a member of a gang called Rock Crew, but that group is no longer going by that name and now goes by YSL, which originally stood for Young Slime Life?
Yes.
Did you also, in that same conversation, advise law enforcement that YSL originally stood for Young Slime Life, but the group began calling itself Young Successful Lifestyle after Jeffrey Williams, aka Young Thug, signed a record deal?
Yes.
Do you also acknowledge that the statements made to police about Rock Crew and YSL, as reflected in sections 3 and 4 above, which I just mentioned, are true and accurate?
Yes.
You acknowledge that you've been accused of and arrested for robbing women?
Yes.
You acknowledge that you are the same person referred to as Tick in the song by Young Thug entitled You, in the verse, She Getting Robbed by Tick?
Yes.
You also acknowledge that on February 4th, 2021, you participated in a group chat with fellow YSL founder Jeffrey Williams, aka Young Thug, and YSL associates Wooney Lee, aka Slime Life Shorty, wherein Jeffrey Williams stated, "YSL rule the world, kid. Y'all just start bringing me the money. Man, y'all stop playing with me." Do you acknowledge that?
Yes.
Do you acknowledge that on May 13, 2021, you participated in another group chat with fellow YSL founder Jeffrey Williams, aka Young Thug, and YSL associates Martinez Arnold, Miles Farley, Quantavious Greer, Antonio Sumlin, Wooney Lee, wherein Jeffrey Williams asks, "Y'all ain't beat him up or shot him yet?" Then states, "Y'all getting soft."
Yes.
Do you acknowledge that the gas station at 151 Cleveland Avenue is a location where YSL associates sell drugs?
Yes.
That also the gas station at 221 Cleveland Avenue is a location where YSL associates sell drugs?
Yes.
And also, do you acknowledge that you cannot truthfully assert that anyone charged in this indictment is not guilty of the crimes as alleged in this indictment, and you will not make any attempt at trial, prior to trial, or after trial to exonerate or exculpate anyone charged in this indictment of the crimes alleged in this indictment, nor will you claim that anyone on this indictment is not guilty of the crimes as charged in this indictment.
Yes.
Do you also acknowledge that if you violate the plea agreement, the district attorney can and will use the statement during any judicial proceeding?
Yes.
You also understand and acknowledge that if you violate any portion of this plea agreement before, during, or after the initial trial of this case, you are subject to having the entirety of your sentence revoked.
Yes.
And you could be sentenced to prison.
Yes.
Do you also understand if you violate any terms of this plea agreement, it will result in your sentence being revoked, and the district attorney will recommend that you serve up to the maximum sentence allowed by law in the Georgia Department of Corrections?
Yes.
Do you also understand fully that if prior to the conclusion of the initial trial of this case, that you fail or refuse to testify to any fact that you now acknowledge in this plea agreement, such failure or refusal constitutes a violation of this plea agreement, and you'll be subject to being sentenced to serve the remainder of your sentence confined within the Georgia Department of Corrections?
Yes.
Do you also acknowledge that no promises, agreements, or conditions have been made other than those set forth in this document, and none will be entered into unless memorialized in writing and signed by all parties?
Yes.
And did you, along with your attorney, sign this document and dated today's date, December 29, 2022?
Yes.
And that's your signature here?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Do you understand if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
What on it?
By law, they have to say that you're probation.
Why that ain't in the paper though?
That's abortion rights. That's
I ain't read it. Can you repeat that?
Sure. I'm letting you know your rights. That's not something that's going to, I can't tell you that's something that's not going to happen. That's not something that we're asking for the court to do. But that's something that's a right that I have to read to you.
All right.
All right?
the constitutional rights. Yes.
All right. So I'm reading your rights now. I'm going back to reading your rights that you're giving up by entering into a plea. Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand if you went to trial, that you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? And after each right, I'm going to ask you to say yes or no if you understand, okay? You understand that you're giving up the right to a trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
The right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case.
Yes.
The right to the presumption of innocence.
Yes.
The right to testify on your own behalf and to present other evidence.
Yes.
The right to subpoena witnesses and compel the production of evidence.
Yes.
The right to have the charges against you proved beyond a reasonable doubt.
Yes.
The right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
With respect to indictment 22 SC 183-572, where you're charged with one count of conspiracy to violate the Racketeer Influence and Corrupt Organization Act, how do you plead?
Guilty.
Is this guilty plea freely and voluntarily given with a full knowledge of the charges against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have 4 years from today's date for the felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
Your Honor, we're going to fast forward to the portions that we agreed upon.
All right.
We're stopping at C.
Good evening.
Sir, do you have the opportunity to fully discuss the facts and circumstances of this? Mr. Stevens, good evening, sir.
Good evening.
Sir, do you have the opportunity to fully discuss the facts and circumstances of this case with your attorney, Ms. Gladden, your satisfaction?
Yes, Your Honor.
Did she explain to you the various constitutional rights you give up by pleading guilty to your satisfaction?
Yes.
Do you have any questions about those rights you wish to ask me?
No, Your Honor.
All right. I am holding the indictment in this case. Okay? And on page 6 of the indictment, I'm going to show you. Is this your signature on the page of this indictment above the word defendant?
Yes, sir.
All right. Before signing this indictment, did you have the opportunity to fully discuss the facts and circumstances of this indictment with your attorney, Ms. Gladden, to your satisfaction?
Yes.
Yes?
Yes.
Yeah.
Do you need more time to discuss it with her?
No.
Okay, all right. But before you signed it, you had an opportunity to talk with her,
Yeah.
and you don't want to talk with her about the indictment anymore?
No.
Okay, all right. I'll note the indictment's been signed and the plea has been entered. I'm going to accept your plea as tendered and as negotiated. To count.
Your Honor, we are stopping at 24 minutes and 17 seconds.
So noted.
Thank you, Mr. Stevens. That's all that I have.
All right, any redirect, Mr. Sharp? Or recross, I'm sorry. Go ahead, sir.
Mr. Stevens, good morning again. I'm going to ask you a little bit about the agreement, the plea agreement that you had with the state. Would it help you if you have that agreement in front of you?
Yeah.
Your Honor, may I approach?
You may, sir.
And for the record, I'm handing Mr. Stevens State's Exhibit 16U, okay? Okay, Mr. Stevens, we just watched a video of you entering your plea on this case, correct?
Yes.
Okay, and that occurred on December 29th of 2022, is that correct?
Yes.
Okay. I want to talk to you a little bit about December 9th of 2000, or December 29th of 2022. The night before you came into court to enter a plea, where did you sleep?
In the cell?
Was that at Rice Street Jail?
Yes.
Okay, and that's the jail that we asked you about a few weeks ago?
Yes.
Okay. And when you were brought over, did deputies bring you over to court that morning?
Yes.
Okay. And when you ride over to court with the deputies, are you by yourself?
No.
Are you with other inmates?
Yes.
Okay, and deputies, correct?
Yes.
All right, you're not with your family?
No.
You're not transported over with your attorney?
No.
Okay. And once you arrive at court on December 29th of 2022, where do they bring you?
Court?
Okay. Do they just bring you directly to the courtroom?
No.
Okay. You're put in a holding cell in the basement of this building, correct?
Yes.
Okay. And how long were you kept in that holding cell in the basement of this building?
Until they ready.
What do you remember that morning? Was it hours?
No, I don't remember.
You don't remember? Okay. When you're held in the basement of this building, are you in handcuffs?
Yes.
Okay.
No.
No? During transport, are you in handcuffs?
Yeah.
Okay, but they take them off when you're in the holding cell?
Yes.
Okay, in that holding cell in the basement of the building, is there TV?
No.
Okay. There's concrete benches, right?
Nah, they metal.
Metal benches?
Yeah.
Okay. And you are held in those holding cells with other inmates waiting to go to court, correct?
Yeah.
Okay. Is your lawyer there?
No.
Okay. Eventually, were you brought up into a holding cell, a holding area for an individual courtroom?
Yes.
Okay. And in that holding cell, is that another cell?
Yes.
Okay. Does that have metal or concrete benches?
Yeah.
Are you in handcuffs when put into that cell?
Yeah, I think handcuffs upstairs.
Okay, handcuffs upstairs. And throughout that whole process of transporting you from the jail to the holding cell in the basement to the holding cell of the courtroom, did you have access to your family at all?
No,
How about your lawyer?
no.
Okay. At some point that morning, did Ms. Gladden, your lawyer, come speak to you in the holding cell for the individual courtroom?
No,
Okay. Did you speak to Ms. Gladden at all before court that day?
no.
Okay. And was that video a video of you in court with Ms. Gladden that day?
Yes.
Okay. When did you initial the factual acknowledgments on your plea agreement? If you recall.
I think it was that day. I think it was that day. I don't know.
On December 29th?
I think so.
If you don't recall, you don't recall.
No.
So is your answer you don't recall?
Okay.
Okay, so you don't recall initialing?
Yeah, I know. I initially, yeah.
Okay.
I don't know when. Yeah, it had to be that day. Yeah.
Okay.
I don't know the date, bro. I mean, I don't know the date, sir.
Okay, it's okay. So initialing it, do you recall if that happened in the holding cell or in the courtroom?
It didn't happen in the holding cell. It happened in the courtroom.
Okay. Just before you took the plea?
Yes.
Okay, do you remember how long you spoke to Ms. Gladden when you were discussing the factual acknowledgments?
I don't recall from, that was like a year ago. I don't know the exact detail.
Okay, just to be clear, Mr. Stevens, I'm just asking you if you recall things. If you don't recall, that's fine, okay?
Yeah.
Okay. This form that's in front of you, 16U, though, that was provided by the state, correct?
Yes.
Okay. Now, this plea deal that we're talking about, that's memorialized on 16U, that was between you and the state, correct?
Memorialized?
The plea deal that you came to agreement with this plea deal. Who did you come to an agreement with?
Yes, the state.
The state. Okay, did you come to an agreement with me?
No.
Did you come to agreement with any other defense attorneys or defendants?
No.
Okay. To your knowledge, to your understanding, who is the party in this case that can make sentence recommendations?
Objections?
I sustain the objection.
Okay, who made the recommendations in your case about what was going to happen to you?
Objection?
Basis.
Relevance? And as
It goes to motive and bias, Your Honor. It's
I'm going to sustain the objection. I think there's another way you can probably ask him that same thing.
okay. In that video, who was the person that was recommending a sentence to you? Was it Miss Hilton?
Who read the paper to me?
Who recommended a sentence? Who did you make a deal with? Was it the DAs?
Yeah.
Okay. And they made a recommendation after you initialed this that you would receive 10 to do 2, correct?
Yeah.
Commuted to time served,
Yeah.
which meant you would go home after entering the plea, correct?
Yes.
Followed by 8 years of probation, correct?
Yeah.
Okay. Were any of the defense attorneys even present when you entered this plea?
No.
How about any of the defendants? Were they present when you entered the plea?
No.
Okay. To your understanding, do any defense attorneys even have the ability to make a sentencing recommendation?
Objection, Your Honor.
I sustain the objection.
I asked to his understanding.
I sustain the objection.
Okay. The terms of your plea, Mr. Stevens, if you go to page 4, you there?
Yeah.
Okay, I'm going to, defendants, you see where it says defendant sentencing acknowledgments?
Yes.
Okay, number 2, it says, I understand if I violate any portion of this agreement before, during, or after the initial trial of this case, I am subject to having the entirety of my sentence revoked to prison. Correct?
Yes.
Okay. And number 3 says, I understand that any violation.
I'm going to object as to ask and answer on direct inquiry.
I sustain the objection because you've asked this before. So,
Your Honor, they just played the tape of the plea.
something else, Mr. Short.
Okay. What does sentence revoked mean? To revoke your probationary sentence means that they would, or someone would accuse you of breaking or violating your probation, correct? Is that what?
Yeah.
And if your sentence is revoked, that means your probationary sentence. Well, let me back up. When you're on probation, are you in jail?
No.
Are you in prison?
No.
Okay, you're given rules, correct?
Yes.
And one of the rules that you're supposed to follow in this case is you're supposed to testify in accordance with this plea agreement, correct?
Yes.
All right. So if your sentence is revoked, that means your probation is converted to a prison sentence, correct?
Yes.
So the 8 years of probation that you were given would be converted to 8 years in prison, correct?
Yes.
Okay. And the state is the party that can move to revoke your probation, correct?
Yes.
Okay. So the state, as we sit here today, if they determine that you violated the terms of your agreement, can move to revoke your probation.
Objection, ask and answer.
I sustain the question.
Okay. When someone moves to have your probation revoked, a warrant is issued and you go back to Rice Street, correct?
Objection, Your Honor, ask and answer.
I sustain the objection.
That has not been asked and answered, Your Honor.
Yes, it has. So,
Okay.
or I'm going to sustain it on another ground. So, on independent grounds. So,
Okay. Your Honor, a juror has a question.
oh. Ladies and gentlemen, let's take 15 minutes, please. All right, take a comfort break. We'll see how the day leads us from there. We're in recess. Mr. Stevens, you step up. All right. Our jury's left us, ladies and gentlemen. We'll be in recess 15 minutes.
Okay, we come. We definitely will be there. You hear about it? Yeah.
One. Can we stop with Mr. Stevens, please?
And Your Honor, before the jury does come in, counsel for the state has informed me that Mr. Steele now requests to put in the NPR video of the lyrics that Mr. Stevens just read. If he sanitizes it, as we did for the plea agreement, take out NPR, take out everything else, and just plays if it's a video of his client, I don't have a problem with that, but we haven't seen it, number one. And
Then why don't we do like we did customarily like last week? You show it to you, and then I can make some determinations.
thank you. Mr. Steele, would you send that to us, please, some way or another?
Ladies and gentlemen, come on in. All right, thank you, Sergeant Ingram. Ladies and gentlemen, please be seated. All right, Mr. Sharp, you may continue, sir.
Thank you, Your Honor. May it please the court. Mr. Stevens, we're almost done. Respectfully, Mr. Stevens, you do not wish to go back to jail, do you?
No.
Okay. And you know that there's nothing defense attorneys can file to send you back to jail.
Objection, Your Honor?
I sustain the objection.
Okay. You are aware that the state can move to have your probation revoked.
I sustain the objection.
Okay. To your knowledge, your testimony is being taken down by the court reporter, correct?
Yes.
Okay. And the state will have an opportunity to review your testimony at a later date, correct?
I sustain the objection.
Does the state have the
Objection, Your Honor?
I think
Speculation.
what?
speculation, yeah, that's speculation, so I'm sustaining the objection.
Please don't speculate, Mr. Stevens.
If you know,
Does the state have the power to move to revoke your probation?
Objection, asked and answered.
I sustain the
He-
objection. It's been asked and answered.
Okay. If it's been asked and answered, then I have no further questions.
All right, thank you, sir.
Thank you.
Anybody else have any recross? All right, Mr. Matthews.
Mr. Stevens, good morning.
One.
Mr. Stevens, on December 29th, 2022, when you entered your plea, you went home in about 2 or 3 days after that, right?
Objection, Your Honor, asked and answered.
I don't think that's been asked and answered, Judge.
I'll rule the objection.
About 2 or 3 days or so processing, you got out, right?
Yes.
And since you've been out, you've had an opportunity to get back to work, right?
Yes.
Get your CDL license or apply for it, right?
Yes.
You've been with your family, right?
Yeah.
And you were able to drive, right?
Yes.
You're able to eat what you want to eat, right?
Yes.
Go where you want to go, right?
Yes.
I'm going to
Now-
this line of question. It was asked.
Basis?
Process previously and answered.
No, well, it's not, Judge.
I'm going to give you a very short window because we did cover much of this already, and you did as well.
Right.
So, all right. So, just
Okay.
I'm gonna allow you a few more questions.
Thank you.
and that's
Thank
it.
you. Thank you so much, Your Honor. So, Mr. Stevens, you were able to do all those things, right?
Yes.
Okay. Now, if you had not taken that plea and gotten out, you would be sitting over here, correct?
Objection, Your Honor.
I stand the objection. Speculation.
Where do you believe you would be sitting?
If I ain't take the plea?
Yeah.
Objection.
I stand the objection.
And everything that we have gone through with respect to your plea, it is your hope that you don't get revoked, correct?
Yes.
Thank you, Judge.
You're welcome, sir. Any further examination? All right, Mr. Steele.
And Your Honor, prior to tendering of any exhibit, we ask that the court allow the state to address and ask that Mr. Steele not tender the exhibit until it has been addressed.
All right, tell you what. Ladies and gentlemen, the hour is about 12:45. How about you take some lunch? Fair enough to you? All right, so, ladies and gentlemen, it's about, if you could come back at, say 2 p.m.? Okay? And we'll continue on with where we left off, all right? All right, remember my admonitions I've given you as well. They apply equally while you're at lunch. And ladies and gentlemen, we'll see you at 2 o'clock, okay? All rise.
Yeah, they complimenting my new Rolls Royce. TV in the front of that motherfucker like a tour bus. Spirit of ecstasy got me feeling so blessed, you see. I told my bitch I was about to go shoot a trust tree. $500,000 on my dogs and all my cars. Couple million to my mama and my pa. Got the sniper on the roof of niggas tryna act hard. I just bought a brand new coupe and it's a black Jaguar. Matte black, old Trans Am, thank you ma'am. We gon' make us a porn star video. New cam, I just came up watching my pop gamma, my food stamps. I just cause cramps, I don't go back and forth with tramps. Baby, we stamp, just for that I'ma call you ma'am. With the T-Bricks, I just gave my daddy the cam. I got the sheets wet, pick that little bitch up, then I slim her like I'm from BX. Then I fold her up like a cram. Yeah, it was dark, then I came to the light. I was pouring down my door, so sorry. I don't know how to make it right. Got 4 Birkins for you, keep it light. I don't care about you leaving me. I got no time to try to make it right. I just hope you find another life. I'll pick you up if you ever fall right. Show me that I'm done, I'm finished here, but still no fear. Yeah. Ain't no more reminiscing, ain't no more judging, no intuition. Yeah. I'm smoking Scotty, but not pimping. I told my son how to stack that shit to the ceiling.
If this is all that they're talking about playing. So, Judge, the objection that we have to this particular video being played is twofold. The state has understood Mr. Steele's objection to or desire to play his client's song. He has couched it as the witness or the state read lines wrong. The state has no objection to the official audio for the song being played for the jury, but not an NPR concert version where, you know, Mr. Williams can ad-lib, Mr. Williams can say, leave out things. And we would object to the NPR logo being shown, all of that. So if the defendant is going to play his video when the jury actually comes back, we ask that the official released audio of the video be played, or if there is an official video, as some artists sometimes make, that was released, we would ask that that be played instead, and not an NPR tiny desk kind of, I don't know, mellowed out version, I suppose. Because it is, for all of the reasons. One, I believe that playing or putting in front of the jury something with the NPR logo it may not be intentional, but it could convey to an audience that is listening or viewing that because NPR let him play it, it's okay, as opposed to, and the version that they're playing could be perceived by the jury as the actual released version of the video, and it's not. It's the official audio. I can play that for the court so that the court can understand where our objection is coming from, considering the reasons being offered by Mr. Steele for wanting to play it.
All right, Mr. Steele.
Would the court like for us to play the official audio?
Yeah, let me hear the other one first, and then I'll address.
Mr. Kearns.
You'll need to also mark it as an exhibit, the next state's exhibit for identification.
Ms. Hilton is about to share.
Pink, live across North America in 2024.
Show me that I'm done, I'm finished here, but still no intuition. Tell me why I'm living, why am I remaining here? I'm smoking Scotty, but not pimping. I taught my son how to stack that shit to the ceiling. Drop a body and you wouldn't have to pay for lunch. I told my dog I'm riding, whether he right or wrong. I done got big, they record my life through a drone. I told my bitch to stay behind me, I'm in my zone. She like, how the fuck you ain't never wrote a song? Same reason your fine ass ain't never wore a thong. You ain't right for life, then I'd just rather ride along. But you a spot, now you don't never gotta go. Yeah. I told my nigga I'ma drop the jewels on him. You gotta go through this shit here with your heart. You can't snooze on it. It's bad, you better get rid of the lose on it. I know you heard that old saying about bad fruit, homie. If you can't beat him, knock it out of me. If you gon' kill him, man, not be slapping. I told my daughter keep one in the head and she ain't gotta cock it. I told my son if he wanted to live, he might catch a body. I told my son he a cheerleader, but might gotta catch a body. His driver named Joe, but he still can't do his slapping. I just hopped up out that ghost. I been driving a dead body. I ain't really into nothing, but I spin it like a hobby. I was locked inside the trap. Didn't think about it, but I got at it. Now my cars and clothes exotic. I ain't 6'9", but 2 hoes with me right now. You can call me Shotty. I been dropping all my beats, and now the FBI won't stop me. Got this shit on fire like a Taki, nigga. Whoa, whoa, whoa. Show me that I'm down. That shit, but still don't feel. Yeah, ain't no more remedies. Ain't no more judging, no intuition. Tell me why I'm living, why am I living? I'm smoking Scotty, but not pimping. I taught my son how to stack that shit to the ceiling. Yeah. They complimenting my new Rolls Royce. TV in the front of that motherfucker like a tour bus. Spirit of ecstasy got me feeling so blessed, you see. I told my bitch I was about to go shoot up the tree. $500,000 on my dogs and all my cars. Couple million to my mama and my pa. Got the sniper on the roof of niggas tryna act hard. I just bought a brand new coupe and it's a black Jaguar. Matte black, old Trans Am, thank you ma'am. We gon' make us a porn star video, new cam. I came up just watching my pop down with my food stamps. I just cause cramps, I don't go back and forth with traps. Baby, we stamp, just for that I'ma call you ma'am. Got that T-Rex, I just gave my daddy the cam. I got that sheet sweat, pick that little bitch up, then I slam her like I'm from BX. Then I fold her up like a crown. Yeah, it was dark, then I came to the light. I was poor, and my dog suicide. I don't know how to make it right. Bought 4 Birkins for you, keep it light. I don't care about you leaving me. I got no time to try to make it right. I just hope you find another life. Won't pick you up if you ever fall right. Show me that I'm down, I'm this shit, but still don't feel. Yeah, ain't no more remedies, ain't no more judging, no intuition. Tell me why I'm living, why am I remaining? I'm smoking Scotty, but not pimping. I taught my son how to stack that shit to the ceiling.
Belize with my best mates, a trip that we had been talking about for years.
So, Your Honor, if 2 things regarding the video, if it's the words that Mr. Steele wants the jury to hear, we would ask that the court require, and especially when the objection is based on, in part, on the fact that we didn't read all of the lyrics, we would ask, if that's his reason, that the court permit him to play for the jury, not a tiny disc concert where some of the words are left out and, you know, it's a different version than what's been released, but to play for the jury the official audio that the state just played as it has been released.
So let me see if I understand your objection. Is your objection based on the rule of completeness and the official audio would be the complete version of the song?
In part, yes, certainly. And
is there another basis for your objection?
Oh, okay. So the other part that we objected to, of course, was the NPR, that tagging, and there's no need to have this setting and Mr. Williams doing a tiny desk concert when...
I understand.
Yes.
Okay.
So I will just wait for the court to address that one. Is he coming up? And I'll after he addresses that, I'll address that.
Ms. Hilton, you'll need to provide the court a copy of what you played from William, Mr. from YouTube.
Yes, Your Honor.
Okay, so what's the next state's exhibit?
40 uniform.
40 uniform for identification? All right.
Yes.
Just want to make sure it's captured for the record.
Thank you, Judge.
All right, hold on. Okay, Mr. Steele?
Your Honor, in October of last year, so it's 2023, I served upon the state the Tiny Desk, NPR Tiny Desk version of this song. So I was wrong when I said, I gave it to him at a break, and I apologized to the court and the state by saying that they didn't ever get it before. It's the same exact situation you don't want me to talk about, but that's not accurate. Again, number two, they're the same words. There are no words omitted. Number three, there's no official release. In fact, the Tiny Desk
YouTube
is
the 40 uniform state played says it's the official song.
Yeah, by whom? And the Tiny Desk is July 27th, 2021, and the version that the state just played, States 40, is October 15th, 2021. So
how do I know this is the official version of it?
It's on his page, the defendant Williams page.
Your Honor, this is my time. I have the man on cross-examination, and I'd like to play this. And then if the state wants,
but their objection is to the completeness and I guess the accuracy of this particular video, which would be Defendant Williams 38.
The only thing that is not complete is when Miss Love read certain logos and lyrics. I am playing the complete song. What Mr. Williams said on NPR is Tiny Desk, which is Mr. Williams number 38, is going to be identical to the lyrics in October 15th, 2021. So I, at some point, get to choose how to do the case, and it's more.
I don't think it's a question of just you choosing the case. You're right. You do get to present whatever case that you, from what position you're presenting it from, but I mean, that's the state's objection. So,
and I listened to a lot of the state's objections, and I disagree with the objection. I asked the court that I did not open that. I was going to play it anyway in my case in chief, but the state asked question after question and lyric after lyric, not entirely. And I want to play the whole version, and I should not be handcuffed by the state saying specious things like they're not the identical versions or it's not the official version. I am playing what Jeffrey Williams said out of his own mouth, live, before this jury. They can see it, and it's more audible. You can hear it better. So that's what I choose to play, and I'd like to play it, and I intend to play it unless, of course, I would obey you always.
All right,
but that's what I'd like to do.
All right, that's the first thing. The second thing is the NPR logo and everything and such as that we, that the state's objected to. Can it be removed?
I didn't actually see it, but I don't know. I can't answer that question, but we can see. But I'll identify it as NPR Tiny Desk, and I will play it. I'm not sitting here,
The state's made an objection as to the NPR issue. I
made an objection as to a lot of things.
I know, and I've removed a lot of the things that for the last video that was thought to be played. It had some objections and it needed to be sanitized.
I didn't want any of that except for.
But I do think that sanitized meaning that it has things that are objectionable. So, and I agreed with that. I agree with the state. You should remove those markings if you're going to play that.
I will orient the witness though, and then I have to ask Mr. Kokum. He gave me a thumbs up, so I assume that means yes, but I don't know. But I assume that means it can be done. I don't personally know.
All right.
But that's what Mr. Kokum.
Ms. Love, I'm going to overrule your objection I'm going to let him play it.
And Your Honor, understood and understanding the court's ruling regarding that. Just as a matter of course, I would ask that Mr. Steele not be allowed to tell the jury or orient the witness by saying that it's an NPR tiny desk video.
I would agree with that, Mr. Steele.
And that.
Sure, over your objection. Over your objection, yes, sir.
And
what the harm is to tell the truth to the jury that he performed it on tiny desk, and that's where it's from. So I respectfully ask you not to limit me. You know, the state of Georgia
Your Honor,
has put in so much character evidence over my objection. Now they're saying we don't want NPR because it's somehow, I don't really know how. I don't really know what's wrong with NPR or what's positive with NPR.
I don't think it's the. I don't think it's the. It's just the. It's kind of like the proponency of the video that you showed that was objected to, law and crime. Okay. I mean, and the state's objected to that particular issue, so I mean, I should probably remove that as well. So I don't think that that's beyond the realm of acceptable things to consider. Because remember, the issue is the song itself; it's not the carrier. So if you could just go ahead and remove that, Mr. Kokomo says he can do it. We'll get it done during the break.
And Your Honor, one more thing.
Just one thing about the law and crime. The reason I was offended by that, and when I say offended, me, and not your ruling or anything, because it says law, which some people would think like that's a good thing to have laws, and crime, and that's a bad thing. And we're charged with crimes. That's why I wanted that gone. It wasn't like, you know, law and the justice system. I wouldn't have had a problem, or just legal trials. I wouldn't have had a problem with that. NPR is not prejudicial to anybody.
You made your point, sir. Over your objection. Please remove it. Okay, so we're going to go ahead and do that over lunch.
And so,
what
Your
else?
Honor, the other issue with that video snippet, Tiny Desk generally plays snippets of songs because it's a 30-minute segment where they play many different songs. The version that Mr. Steele is asking the court to play, I'm assuming for the rule of completeness, is not the complete version. The version that is the complete version is the version that is on the defendant Jeffrey Williams's YouTube site, where he says this is by, and Ms. Hilton will share it with the court as I'm speaking. It is the version that he released himself on his site. So we're asking that since it is for the purpose of playing the actual lyrics that are being spoken by Mr. Williams for the jury in their entirety, that Mr. Steele not be allowed to cut out portions when that is the sole reason he wants to play it, and that he be required to play not this different version than what he has actually released. So, and the court can see Young Stoner Life records exclusively distributed by the entity after that, and hashtag Young Thug, hashtag Droppin' Jewels, hashtag Pump, and so forth and so on. This is from the defendant's own website, and when he is offering it up for the reasons he is at least represented to this honorable court, we would ask that he not be allowed to confuse the issue and not play what is actually the official audio that the defendant himself released to the rest of the world, as opposed to the video.
All right.
Thank you.
It seems like maybe I need to get granularity on this. Might not be something I play right now. It'd be played right now because both of you have thrown around the word official, and I don't know what official is, and unless you all can agree upon it, because the reason I say this, counsels, is that it affects the rule of completeness. So there's either got to be an official release, which has all the song, and not just a remake of the song or a riffing of the song or whatever. But if that's the purpose of playing that particular song, then we need to have the correct version, because there may be different versions out there, all of them claiming to be, an original release. And I mean, and I'm okay, and I understand that artists release whatever versions for whatever medium or circumstances that they choose to do so, and that's their purview. But for this particular evidentiary issue, it would have to be something that both sides can agree upon, or somebody's going to have to come in here and tell me this is what happens when that the official song is this.
Your Honor.
Is it the Recording Academy? Is it whatever? I don't know. But
Your Honor, you are being, and I'm not saying it's intentional, you are being misled across the aisle from where I sit. The words are identical. You keep being told something that's not accurate. So I will be playing like you ordered, unless you changed your order. I will be playing.
I haven't ordered. I haven't ruled yet.
You overruled the state's objection, and you said that I could play what I want to play. And then Ms. Love just.
But they're telling me that that's not the original version.
You asked,
the tiny desk. The tiny desk.
Ask the question. What is omitted? The answer will be nothing.
Has anything omitted, Ms. Love? Is there anything omitted from the Tiny Desk version versus the YouTube version?
Your Honor, if the court looks at the time alone, the court can see that. But the point that we're making is that we ask that the court listen to both of them, and then.
And I can't really, and I'll be honest with you, I can't really tell other than.
Then the court allow us over the lunch break to compare the two. Since
Sure.
there is an official version.
Absolutely.
And so we will do that, and we will bring that back before the lunch break ends.
Okay.
And when the court tells me that the time is appropriate, I would like to address the second exhibit that Mr. Steele.
What's the second exhibit now, Mr. Steele? Is there something else you were gonna?
He has said, Mr. Steele has indicated that he seeks to introduce his client's words, and that is absolutely.
Client's words in terms of what?
An interview that Jeffrey Williams did about Jeffrey Williams. And so under 24-801 the defendant Jeffrey Williams can take the stand and talk about what was in his head, but he cannot introduce it himself.
24-what?
8-801 D1 801 D1. Just 1 second, Your Honor.
Are you talking about prior consistent statement?
No, Your Honor. 24-801 D2A. 24-801 D2A, which says an admission, it's speaking to admissions by party opponent. A party's own admission offered by an opponent is not hearsay and is always admissible. This interview was not offered by the state. It is being offered by the person who spoke it. And here, however, according to Morales, Morales, versus the state, 337 Georgia App, 614 at 618. It is a 2016 case. A self-serving declaration, such as a statement of one's innocence and a statement of what words may mean, remain inadmissible hearsay unless the declarant testifies and is subject to cross-examination. And in this case, with what Mr. Steele is offering, the declarant is the defendant, and the defendant has to be subject to cross-examination by the state in order for the defendant to be able to properly admit the defendant's own interview in any venue. The state did not introduce that, and the defendant cannot circumvent 24-801 D2A by making assertions that somehow, well, I'm not sure how he is attempting to get it in. He cannot get in his own words. He would have to testify. A declarant cannot attempt to introduce any such statement. It is well established in both state and federal law. And defendant counsel Steele cannot cross-examine the defendant about his statements made in the interview, whether the witness heard those statements, whether the witness saw the interview. Under no circumstances can Mr. Steele properly admit or have admitted that interview that the state has not sought to introduce, or examine the witness Trontavia Stevens or any other witness. He cannot examine or cross-examine a witness about the defendant's own statements or otherwise, unless the defendant is subject to cross-examination on the same. And I will point to United States versus Green, CR 415-204-3. It's a 2016 U.S. District Court case, and it's at Lexus 66739 at 3 out of the Southern District of Georgia from May 20th, 2016. Again, the state may properly introduce it, but as stated in Carlson on Evidence, the most recent 8th edition, the state or the right of a party to introduce the opposing party's statements is being affirmed by 24-801 D2A. And according to, as reading in Carlson, since the definition of an admission includes admissions by conduct, a party's flight is implicated, and this rule is intending to adhere to federal formulations, and it allows for a standardized approach with respect to other specific issues such as flight. But as it relates to the defendant's statements, they are, the only way that they are not hearsay is if the state seeks to introduce them. Otherwise, they are inadmissible and should be excluded. And as they go on to talk about in Carlson's regarding the policy and rationale, out of court statements made by a party opponent, if we were offering it, are an exception to the general hearsay rule. And this exception reflects that the adversarial process allows the party declarant to rebut his or her own statements by testifying at trial. Relevant admissions of a party are generally considered substantive evidence, but and those statements are not admissible because of their inherent trustworthiness, but because a party cannot object to his failure to have a chance to cross-examine himself. If the state is forced to endure the defendant introducing his interviews left and right without being given the opportunity to cross-examine the defendant, then the state is unfairly burdened and is not allowed the opportunities that the law requires as it relates to a fair trial and getting the actual truth in front of the jury, and the defendant can just put in whatever words he wants that he speaks without ever having to endure cross-examination. Thank you, Judge.
All right. Mr. Steele?
Your Honor, 24-8-801 D2A, I hope the court finds does not apply. This is not a self-serving statement. This is a statement from 8 years ago, and it goes exactly to the topic that the prosecution asked a number of questions. I don't know how many, maybe 10, but I don't know how many, about Mr. Williams. Where in his songs does he say, God, truly humble under God? Mr. Stevens understood that to be humble. Mr. Stevens understood that to be God. Mr. Williams gives an interview. He explains, I want to be Jeffrey. Young Thug is a brand, but it sells millions, it makes millions of dollars. I want to be humble. I want to be harmless. Everybody now, because of my brand, comes at me, and I have to go hard at them because that's what I portray. But I don't want it to be like that, and I don't want my children to be like that. That is all encapsulated. What Miss Love did is what courts have told me, what you told me actually during this trial. I may have opened the door. I may open the door. I could be opening the door. Miss Love opened the door. She now leaves the jury with the impression that this was made up, that this is not about being humble, that Mr. Williams is not about anything except a gangster. And he gives an interview well before this. The state cannot sit here and say the jurors get the truth and then hide the jurors in secrecy. She should not have invited those questions at all. But she did, she being the Honorable Miss Love. And I get to cross them because otherwise.
So what's your basis for saying it's admissible? And how long? That's my first question. Second question is, how long is the interview?
3 minutes. It's longer, but I'm just going to show the relevant part. But I'm going to put in the whole thing. But I'm just going to show the relevant part at 3 minutes. It starts at 9 minutes and 10 seconds, and it goes for about 3 minutes.
Your Honor.
It might even be less.
Here's the issue.
It might be less than 3 minutes, actually.
So what's your evidentiary basis for putting it in, Mr. Steele?
Because I am going to show that the impeachment of the state on redirect was erroneous, and that this witness has knowledge that it's erroneous. He keeps saying
it's got to be that witness's statement. It's got to be that witness's statement.
They're asking about Mr. Williams' statement. That's all.
No, but what you're trying to introduce is what's a better part of a prior consistent statement.
No, I'm not trying to do that. Ms. Love put in on cross-examination, excuse me, on redirect, she said, when did Mr. Williams ever say truly humble under God in any song? Then it got into a conversation about God. That's how you got into that song that we've been talking about.
Dropping Jewels.
Exactly. That's the whole way that God got introduced into this case. Then Ms. Love, that was before the break. Ms. Love then, today, continued that. And she said, name any song, anything, where Mr. Williams talks about truly humble under God, humble God. And she put the gentleman on the spot, and he said, I know what he's saying. And Ms. Love then started to read the words out of context and not complete of the song Dropping Jewels. So I want to show that that man is not lying about this, that Mr. Williams has said to everybody, and I've served it on the state, has said, this is a big deal to me. And that's why I would like to bring it in. And I don't believe that the state can hide behind 801D2A when they open the door. They shouldn't have asked these questions. The evidence is there, and it's not a statement that goes to innocence. It has nothing to do with innocence. It goes to show what the state is going to do if you don't allow something like this. Is if we were at a closing argument, they would say, that whole thing is made up. There's nothing about being humble. There's nothing about God. You heard Dropping Jewels, and sure, one part is interpreted as God, but he never says God. That's exactly the opposite of the truth. And she was asking Mr. Stevens for the words of Mr. Williams. Those words are clear. So I asked the court to admit them.
Your Honor, briefly, Mr. Steele opened the door, and during opening statements, the state intentionally did not want to prejudice his client in any way when he began offering self-serving statements about thug, meaning truly humble under God. We approached, the court heard our objection. They're self-serving. This is a self-serving declaration by the defendant Williams that Mr. Steele not only opened the door on, or even spoke about rather, he cannot open the door to have his own client's words admitted over 24-801D2A. Not only did he speak about that in opening statements, knowing, because I said, if his client is going to testify that that's what it means, then fine. Mr. Steele at the court's bench said they are going to be able to get it in. And so what Mr. Steele did was ask Trontavious Stevens on cross-examination about various aspects of the defendant being, I guess, truly humble under God. What Mr. Stevens did was talk about what he knows the defendant has rapped about. And when I asked him, because he's a founder of YSL, okay, well, how many songs has he written about God? And then Mr. Stevens starts to talk about this. The reason we don't object to the audio of Dropping Jewels being played is because the only thing that Mr. Stevens can talk about, because he's the one opining that this is about God, we don't believe it's about God at all. But the only thing he can talk about is what he heard. He responded that dropping jewels is about God. So I said, okay, tell me what part. Is this about God? Is this about God? To suggest somehow that because Defendant Williams in opening statement makes this absurd assertion that this means whatever he claims it now means.
But here's the thing: he doesn't have to present anything.
He doesn't.
And remember, opening right. remarks and closing statements of counsel are not evidence.
Right. I don't disagree with the court on that at all, but it still does not, even aside from him saying whatever he wants to say in opening statements, that interview by his client is not just a self-serving, it's not just a declaration by his client that the state would not get the opportunity to cross-examine his client on. It's a self-serving declaration, regardless of when it was stated, and we in no way open any doors to him putting that in. The only way we would do that is to play it ourselves. And if the court would permit me one moment.
Mr. Steele, this is an interview that you're trying to introduce, and what's it going to be marked as?
Mr. Williams, number 39 on today's date, Your Honor.
And also, Your Honor, Ms. Hilton has just further brought other facts that we would like to bring to the court.
Can I rule on something first? Can I just can I get just a little bit of
I'm so sorry.
time just to kind of consider what you told me so far?
Yes,
right.
thank you.
All right. Okay, so during the break, you all are going to work on whether or not, or come to some agreement on Defendant Williams 38 or State's 40. As it pertains to Defendant Williams 39, Mr. Steele, I'm at this point in time believe it would be, I'd probably sustain the State's objection in regards to it being coming under 24-8-801D2 alpha. So at this point in time, I'd probably not admit that statement at this point. However, I'm not going to say it's not admissible at some point. Should you choose, or should the door be opened by somebody else? I'm not saying that the statement might not have any relevance or probative value, but at this point, through this witness, it would violate 24-8-801D2A. All right. So unless there's anything else, folks, I'll see you in about 30 minutes, okay?
Thank you, Judge.
Okay, starting with everybody here.
Looks like everybody's present and accounted for, Judge.
Okay, when we recessed councils, we were talking about defendant Williams 38 and states 40. So we proposed or got into a resolution of that.
So, Your Honor, Mr. Brown is going to go and look at what they have put together, Your Honor, on conferring further with counsel for the state, D.C. Carlson in particular, with respect to defendants 28, was it?
38.
38, thank you, Judge. The video itself, Your Honor, is inadmissible hearsay under 24-801A through C and 24-802 and Rule 613. Per 24-801, the exhibit does not have to be self-serving as it did under the old Georgia law, only self-quoting. That is what makes it hearsay under 24-801A through C. And it is therefore inadmissible under 24-802. To properly have the video admitted, the defendant bears the burden of providing to the court an exception or an exemption to the hearsay rule, and the defendant has not met that burden because there is no exemption or exception that applies. The video is not a prior consistent statement under Rule 613 because the defendant has not testified. Therefore, the statement is banned as bolstering before impeachment under Rule 613. Your Honor, with respect to the video itself, the state has left the jury with no misrepresentation or false portrayal about what the lyrics of the song are. And so the rule of completeness and doctrine of curative admissibility do not apply. The meaning of the lyrics is a jury issue that the defendant cannot prove by circumventing the hearsay rule with the self-quoting video. Even for the sake of argument, if the state has in some way misrepresented to the jury what the lyrics are, the state did not introduce a video. So a video is not admissible under either of these doctrines. The only thing then that would be even conceivably admissible would be the specific additional lyrics that provide a different context than the ones the state introduced from that particular song with this witness. Lastly, Your Honor, introducing the video is barred by Rule 403 in that it would confuse the issues for the jury. Because while we here now are focused on lyrics, suddenly the defendant would be introducing a video. That comes in, and that is confusing the issues as to what they really are. And so our position is that it is barred by Rule 403 under confusion of the issues, Your Honor. So when the court asked the state to look for lyrics that were different between the two versions, it is actually the defendant, if that is his grounds for having to admit the inadmissible hearsay video, the defendant bears the burden of presenting to the court what misrepresentation the state has made, and then he is limited to playing only the portion of the song that would then give proper context to whatever misrepresentation regarding the lyrics that currently exist as the state presented in that particular song. I would also point out, Your Honor, that it was the defendant who asked and brought up on cross-examination. We're not even talking about open, but on cross-examination, the defendant specifically asked Mr. Stevens, does thug stand for truly humble under God, Your Honor? And that is the only reason the state went back and said, if this is what his name stands for, and he sings about everything else, how many songs has he written that talk about being truly humble under God? So in the 8th edition of Carson on Evidence, Your Honor, page 269, page 80, page 51, and page 432, page 336, and page 438, all pertain to the inadmissibility of this type of evidence, and the video in particular. And this defendant simply is not permitted to make a circumvention of the rule excluding hearsay. He has not provided an exemption or an exception, And I think that I see the court has a version of Carlson, and if I've given the court information from a edition that the court.
I'm not as rich as you all are, so I don't have the most recent version, but I am familiar with Carlson on evidence, so I'm good. I'm good on that. But
thank you.
Anything else? Okay, all right, Mr. Steele, anything, sir? In regards to, I guess, it'd be Williams 38 for identification.
I made my record. There are no differences in lyrics. The prosecution
Introduced lyrics out of context on redirect under the rule of completeness and under truthfulness to this jury. I would like to do what you already ruled and play the song. And I don't even understand how we're at 24-6-613, prior consistent statement. That's not even close. I mean, we're talking about, you're saying, okay, it's snowing, and we're talking about, well, let's go, so since it's snowing, let's get our pails and shovels to dig up the sand. I mean, this is crazy, their argument. So I didn't bring this up.
Okay.
No intention of playing it.
Mr. Steele, I do understand that. I really do. But
I just want to play the song.
But you can't at this point in time.
Yes, I can. It was brought up with this.
Okay, but you know what? It's still inadmissible at this point. It's not admissible at this point. I would agree with the state under 801, 24-8-801 A through C. 802 and 613.
At some point, the confrontation clause has to speak in this courtroom. The state of Georgia asked and leveled lyrics words made by Mr. Williams. I want to put those words in proper.
Okay, but you won't be able to do it through him. It's objectionable.
Right person.
It's objectionable at this point in time. I'm not saying that it's not. I'm not, like I told you before. It's not that it may not be objectionable at this point, but if evidence comes in for different reasons, Mr. Steele, at this point in time, it's just not coming in. I'm not saying that it won't come in at some point in time.
This court is handcuffing the Constitution. Then I move to strike everything said by Mr. Stevens in its entirety, because I can't confront him. You have the awesome power to control these proceedings. But the state of Georgia, wide open that door. I didn't mention anything.
Okay, but that does not make the evidence any less inadmissible. It doesn't.
They took words out of context, and I want to put the words in its entirety the way they are. You should be able to let me see the road to do that, Your Honor.
I just can't let you do it right now, Mr. Steele. It's because the state's objected to it, and I agree with them under 801. A through C.
Well, they're wrong. Mr. Carlson has no clue what he's talking about. He's wrong. He wasn't here. And just to throw around a name because he wrote a book, this is not applicable. Your Honor, the state of Georgia said this is what Mr. Williams said. I'm saying actually what he said was this, and I'm putting in the completion of the story. You know what this song is about? It's about coming from nothing. It's about telling your kids, not that you're riding around with a body, it's about telling your kids, if you live under the circumstances that a gentleman like Mr. Williams did, you may have to kill somebody because they're going to kill you. It's self-defense. The state of Georgia wrapped all that up in little lyrics and misconstrued what they are. I have every right, I need to put this in. And it's not good enough to say later, Judge, this trial, I have no clue, I've never been in a case like this. This trial may go on till Super Bowl next year. I don't want to do it in 7 months. It is right now, and I should have the authority to do it, Your Honor. You know, I'm doing everything that I know to be upfront. I give everything I don't have to give. I give everybody a heads up, and it gets spun around. I get to play this song, the song I want to play, and I ask you not to keep doing this and listening. Once you rule, it's coming in, which one? The state was saying before lunch, I'm somehow changing the lyrics. The lyrics don't change, I tell you that. Now it's all of a sudden another reason. Your Honor, you have ruled, I use your ruling, I embrace them, and I am correct.
There has to be a point that we have traction here too. It is a two-way street.
Well, remember, Mr. Steele, I can always, one of the things about being a trial judge is you can reverse your rulings. And also, here's the other thing as well. You all as a group, kind of release or give me snapshots at any given point in time. And I make a ruling on it. Then more comes out, and I sometimes at that point when I get a full picture of everything, because remember, this is part of what challenge I told you about earlier. When it unfolds this way, I don't get to make the best ruling I can at the first time. So unfortunately, I'm kind of hamstringed in terms of that, but I do have a mechanism of kind of reconsidering. I want to get it right just like anybody else does.
Your Honor, I learned about it today. Today, dropping jewels was mentioned on redirect. I brought it to the court's attention and the DA's attention even before that. Your Honor.
And that's why I'm not fussing at anybody about it. I'm not, Mr. Steele.
I get to put it into perspective.
Not now.
Oh, Judge, please take a
Not now.
break and reconsider, because this is important.
Everything's important, Mr. Steele. Everything.
But good. Then I need to put it in. You told me over and over again, there's a battle of the titans. You could cross-examine. Well, I'm here.
Okay, you're doing your job.
I want to do this. Every time the state wants to put in something like that last video of Mr. Stevens, I strenuously object. You overrule it and you say you can deal with it on cross. Well, the state's the one who opened the door. I get to go into this. They just mentioned a song and lyrics from the song. They knew what they were doing today. They brought lyrics with them. It was mentioned before Mr. Stevens ever came. They didn't ask you, hey, I'm going to mention lyrics. They just do it. I get to respond. Your Honor, this is critical to me. They are trying to paint Mr. Williams as a person he is not. This is a good man. And I get to show the truth about that song. I didn't introduce the song. I gave it in discovery because I will introduce it later. But now it's right. And if you don't let me do it, jurors form opinions. I know you're instructed, but they form opinions. That's why we confront witnesses immediately. It is wrong to exclude it at this time. It was wrong to exclude respectfully lifestyle. They put in the rich gang shirts. I want to show what lifestyle is. You told me do it with another witness. Your Honor, this is the witness. I need to do this. This is the only way I can get that trial.
Look, you have the right to present whatever it is that you feel you must on Mr. Williams' behalf, as each advocate does here. But there is a certain order. As you all know, that the evidence code requires certain pieces of evidence to be admitted. So subject, or unless they're by agreement, if there's an objection, then I have to rule on it.
Judge, this was the state's doing. They used part of a song. How is it just? You're a great man. How is it just that the state got to put in with their own inflection of voice on lyrics and say, did this what the song says? And Mr. Stevens saying, yes, it does. Next lyric, is this what the song says? Yes, it is. The next lyric, is this what the song said with the expression? I'm not going to say it, but the emphasis on the word F. U blank K. And then I sit here, mute. That's just, they did this. And I get to put it in perspective.
Okay, but
I need to do it now. And it's right now because it's a rule of completeness. The witness knows the song. He knew it from his memory. Miss Love was saying, you know the song, and here's the song. Here are the lyrics. I want to put in the actual song. The way I want to put it in the video, and then we're done. But Judge, to exclude it, it makes it look like I'm conceding it, and I'm not. And I would not have. And to hide behind a hearsay statement when you open the door on that specific statement. I was thinking about this over lunch. What if the police officer, for example, said, yes, Mr. Williams gave a statement to me, and he admitted being there at the time of the incident. And then the state sits down. And then I want to get up and I want to say, I want the whole statement in. Mr. Williams admitted that he was there at the time of the statement to help the victim. How is that not the same here? The state is saying, Mr. Williams said this, 1, 2, 3, I think it was 4 different lyrics. Why can't I say, but Mr. Williams put in context, and that is what the song's about. The state cannot now tell the court, let's keep it away. It is wrong. Your Honor, I'm not begging. I am respectfully requesting this honorable court to do what you already ruled, and you do have all the information. It was the state's doing. It's not like I'm just standing up and saying, I want to play every one of Mr. Williams' songs. I picked this song because the state picked the song. I picked the words because the state picked only a portion of the words. And I picked the Tiny Desk because it's clarity. It's easy to hear the words and the lyrics. That is all admissible. If the state wants to play the other rendition, I don't care. Play it all day long. But it's not for the state to tell me what I can and cannot do on admissible evidence. And I ask the court to please permit me to try this case so the man has an opportunity to get the truth out. It has been maligned.
All right, sir, thank you. I'm going to be in recess. purchase.
I took those. I'm putting them here when I tell you I can't find it.
Okay.
Merci, co-conductor.
Okay, the court's had an opportunity to consider more arguments of counsel. In terms of Appendix 38, States 40, I'm not going to do them this time. I'm sorry, Mr. Harvey. I said, as it pertains to Defendant Williams 38 and States 40, I'm going to not admit them at this time. All right, can we call for our jurors at this point? Let's call for Mr. Stevens, please. All right, summon our jurors, please, sir. All right, ladies and gentlemen, please be seated.
I'll do President California.
All right, thank you, Sergeant Ingram. All right, any further examination of Mr. Stevens? Mr. Steele? Go ahead, sir.
Good afternoon, sir. Mr. Stevens, do you remember today the prosecutor was asking you questions about a song called Dropping Jewels?
Yes.
And do you remember her with her inflection of voice? What that means is her tone of voice, the way she was speaking, giving you certain lyrics allegedly from that song. Do you remember that? It's not a. It was one question.
Just rephrase it, Mr. Steele.
Do you remember? Okay. No problem. Do you remember the prosecutor asking you questions about certain lyrics from that song?
Yes.
And do you remember they were a series of questions? I don't know how many, but 3, 4, 5, 6, something like that. Do you remember that?
Yes.
And do you remember her voice stressing certain words?
Yes.
And do you remember, like, and I'm not going to say it, but, you know, for example, when the Honorable District Attorney Love stated the word, it begins with an F and blank CK. Remember how she raised her voice for that? You remember that?
Yes.
Okay. Now, you clearly know the song Dropping Jewels, right?
Yes.
And you've heard that song multiple times, right?
Yes.
And it was written by Jeffrey and a man named Chandler Durham. Remember, let me ask you a question. Do you remember the prosecutor asked you, do you know Chandler Durham?
Yes.
Okay. Do you know a gentleman named Turbo?
Yes.
Okay. And Mr. Williams or Jeffrey wrote the song with him. Do you know that? And if you don't know, just say, I don't know.
I didn't know that.
Okay. Now, Dropping Jewels, the name of the song, tell, ladies and gentlemen, jury, what does the expression dropping jewels mean?
Objection, speculation,
That's
as it relates to the defendant's song.
I sustain the objection. If you can lay a foundation, sir.
Have you heard the expression dropping jewels before?
Yes.
Do you know what it means?
Yes.
Can you please tell the ladies and gentlemen jury what the phrase dropping jewels mean? They may not know.
If it does not apply to the defendant's song, it has no relevance.
If
it does apply to the defendant's song,
Okay, all right. Let me rule on the objection. I'm gonna overrule the objection. If you can answer, do you know what dropping jewels means?
Yeah.
All right.
Like teaching somebody like wisdom or knowledge.
Okay. Just because I couldn't hear you, can you just repeat that to the jurors if you don't mind?
Teaching someone like wisdom or knowledge.
And in those lyrics that you were asked about, we're going to go through a few of them, or all of them if we can. You were asked about a lyric, something to the effect of, and I'm not saying the prosecutor said it correctly, but something effective. I told my son if he wanted to live, he might catch a body. Do you remember that as a lyric in the song that you were asked about?
Basis.
as to mischaracterization of what I said, and mischaracterization as to the lyric itself.
All right, I'm over the objection.
Do you remember that?
Yes.
Is that a lyric in the song?
Yes.
Okay. And from where Jeffrey came from, was there times that people had to defend themselves?
Objection, Your Honor, speculation.
I sustain the objection.
Where you came from, were there times that people had to defend themselves?
Objection, speculation,
And
relevance.
Well, I sustain this irrelevance.
If somebody wants to live and they catch a body, well, what does catch a body potentially mean? I know it can have a different version, but what does potentially catch a body mean? Tell the jurors.
To like kill somebody?
Okay. So if somebody wants to live and they have to kill somebody, you ever hear of self-defense?
Objection, Your Honor.
I sustain the question.
Do you know what that lyric means
Objection,
to you?
Your Honor, speculation.
I'm asking about
I think
Mr. Steve.
I think he's answered that question. Can we move on to something else?
With regards to, you were asked about, I just hopped up out that ghost. I've been driving a dead body. Is that a lyric in the song?
Yes.
Okay. Tell the ladies and gentlemen, jury, what a ghost is.
Objection, speculation.
If you know.
I sustain the question. You can rephrase, sir.
If you know, is a ghost a Rolls Royce
Objection,
vehicle?
Your Honor, speculation as to what ghost means in this song.
I asked.
Okay, well, let's just.
I didn't ask.
Ask him the question.
Does Rolls Royce make? Do you know what a Rolls Royce is?
Yes.
Is it a vehicle?
Yes.
Does Rolls Royce make a vehicle known as a ghost?
Yes.
And If you're driving a ghost, are you driving a dead body?
Objection, Your Honor.
Basis.
Speculation.
I'll sustain the questions to that.
Is a ghost somebody who already died?
Objection, Your Honor. Relevance.
I sustain the question.
Is that the lyric in the song that you asked about? Is that the line?
Clarification.
I'll overrule that objection.
Is that the line you were asked about?
Yes.
Okay. Does it have anything to do with killing anybody?
Objection, Your Honor. Speculation.
I sustain the question.
Who is it? Okay. You were asked about the line, or is this the line first? I was locked inside the trap, didn't think about it, but I got out of it.
Yes.
Okay. And is that getting out of a neighborhood,
Objection,
a bad neighborhood?
Speculation, and I object to any questions regarding what Jeffrey Williams means in these lyrics that the witness is reading.
I sustain it as to the question posed right now.
From what the prosecutor asked you is, I was locked inside the trap, didn't think about it, but I got out of it. Is that getting out of the neighborhood?
Objection, Your Honor.
That's asked and answered. I'll sustain the question.
Do you remember the lyric, I just came up watching my pops gamble my food stamps? Is that a lyric in that song?
Yes.
Is a lyric in the song, is it bad, you better get rid of it, or lose on it? I know you heard that old saying, folks round about bad fruit. Is that the song, the lyric? No? Tell the lyric.
No. You didn't say it right.
Go ahead.
You want me to say it?
Yeah. Tell the jurors.
Started off, let me see what part you was on.
Okay. Is it bad? You better get rid of it or lose on it. I know you heard that old saying, folks round about bad fruit.
Oh.
That's fine. Mr. Stevens,
If it's bad, you better get rid of or lose on it.
Okay.
I know you heard that old saying about bad food, one of them, fruit or food.
One bad apple spoils the bunch.
Objection, Your Honor. That Mr.
I'm
Steele
asking.
is asking what the meaning of the lyric is because there is no testimony.
So what's your objection, madam?
So objection as to speculation.
I sustain it.
I'm not asking, okay.
Just I sustain it.
To you, that old saying, what is that old saying?
Objection.
If you know
Objection.
What are we talking about?
that the lyric refers to.
Objection. Speculation.
Mr. Steele, I'm going to sustain it. Bring him back to what is it you're asking him about in terms of the, because I don't think he's been able to identify anything at this point, so.
Dropping jewels, Mr. Stevens, is about teaching,
Objection,
right?
Your Honor. Speculation.
He already said that's what it means,
Your Honor, as to the song.
I'm going to overrule the objection.
correct?
Yes.
I couldn't hear you.
Yes.
And Mr. Williams talks about his son and daughter in that song, right?
Yes.
And he wants them to know what a struggle it is, right?
Objection. Speculation.
I sustain the objection.
That's what the song is about to you.
I sustain the
isn't
objection.
it?
Speculation. So objection.
To you. Is that what the song is about?
Objection, Your Honor.
The state asked all about the song.
Hold on. I'm going to overrule the objection. Let me get the question out first.
To you, the song Dropping Jewels, it is teaching children to go a better way, right? Teaching about the real life, right? Warning them.
To me, he's talking to his kids and he's talking to other people too. Teaching, saying the things, life coping skills, I don't know.
Okay. All right. Now, I want to talk with you about some of the chats that the prosecutor was asking you about, okay?
Yes.
And I just want to start here. Your Honor, with the court's permission, can the Honorable Mr. Kokomo put up Mr. Williams number 2? It's already in evidence.
Yes, sir.
Your Honor, will the court permit me also to just grab that from the court reporter stand just to follow?
Yes, ma'am.
Thank you. You took Mr. Steve for this.
I have.
Okay. Just give me the page numbers from that Exhibit 2 consists of at the very top of the page.
1603.
1603 to
2 pages.
to 1604. Okay. Is it 1605?
Mr. Stevens, if you don't mind, and if you can't see that for whatever reason on your screen, we have it in evidence already. You can look at it, okay? Just let us know. I'd like you to just show...
Your Honor, I'd object as to the state having asked no questions about 1603. We asked about Defendant Williams 4, not 2.
Sorry, is this defendant's, which exhibit is this? I'm sorry.
Number 2, Your Honor. Mr. Williams, number 2.
Is it in evidence already?
Of course.
All right. Let's see where it's going. I'm going to overrule it for the time being. Slow.
Okay, you see at the very top right-hand corner on Mr. Williams, number 2, it says 1603. You see that?
Yes.
Okay, and then the next page, just to give you an idea, and it's the second page of Mr. Williams, number 2. For ladies and gentlemen, jury in this honorable court, you see in the right-hand upper corner, it's in like blue and white, 1604. Do you see that?
Yes.
Where it says Instagram business record?
Yes.
Okay. If you can just remember, if you can, otherwise I'm going to show it to you, no problem, 1603. If you could try to remember that. Now, in 1603, on the page before, Mr. Kokomo, at the bottom, towards the bottom of that page, you see at, let's see. See where it says Booley with 2 I's, 1 at 1:59:09 UTC time on your, like kind of like the top center of your screen. See where it says that Instagram user-centered attachment?
Yes.
And the text says yo at Little Uzi Vert. You see that?
Yes.
And that's the gentleman you already explained to, ladies and gentlemen, jury, on that date, which is February 4th, 2021, revealed that he had a surgically implanted...
Your Honor, asked and answered on cross, and I didn't even ask about it on redirect.
Oh, objection.
And that's the gentleman who you already talked about on that date, revealed that he had a surgically implanted pink diamond in his forehead. Is that fair to say?
Yes.
Okay. And that gentleman's a performer, right?
Yes.
And then underneath it, it says this reel. Is that fair to say?
Yes.
And then the next one is that N Uzi Crazy. This is all about his diamond in the forehead, correct?
Yes.
Okay. And then that boy take a punch to the head, it's over. And then on the next page, which is 1604.
Your Honor, I object to this. I don't know if that was a question, but if it's testifying, I object to testifying.
I'll sustain this to the form of the question. You can rephrase, sir.
I was just asking Mr. Kokomo to go page 1604. And you see that at the top, they tripping now?
Yes.
And then he cap. And then Jeffrey, YSL Rule the World Kid 24M on an N's head. You see that?
Yes.
And then you said came from nothing for something, right?
Yes.
Okay. And then you already said it, but in Mr. Williams' number 3, which was played to the jury, That's talking about, which I'm displaying, Your Honor, already in evidence. It's a video that the jurors saw. That's the photograph of Mr. Little Uzi Vert having the pink diamond in his face, right?
Yes.
All right. Now, I want to show you what already been identified by you.
Your Honor, as to the line of questioning regarding Act 127, I'd object us to asking this.
I stand by that.
Okay, I'm going to show you, I didn't ask the question, Your Honor. Mr. Williams, number 17, it's already been displayed to the jurors, Your Honor. I asked to display it again. It's over to Act number 127.
Yes, sir.
Now, I'm going to hold it up. I've been told that jurors can't see it, so I'm not going behind you, okay? Can you see it, though, Mr. Stevens?
Yeah.
All right. And you see where it charges in count 1 over at Act 127, February 4th, 2021, that these gentlemen, Mr. Lee, yourself, and Mr. Williams, associates of YSL, did engage in conversation with Mr. Williams states
Your Honor, I object.
YSL.
He has already asked the same exact question on cross-examination.
Let him finish and then I'll make a ruling.
Yes, sir.
YSL ruled the world, kid 24M on an N's head. You see all that?
Yes.
And then the next line, it doesn't have any type of comma.
As to the commentary.
I'm on cross.
Is there a question though, Mr. Steele?
Yes.
Okay, all right, what's the question?
I'm getting there right now. And you see how it just continues in the indictment? Y'all just start bringing me the money?
Yes.
All right. And then, man, you ends, stop playing with me. You see all that?
Yes.
All right, now you remember that 1603 and 1604 that we discussed already?
Yes.
All right, now I want to show you what's already been marked with Mr. Kokomo's permission, Your Honor, and admitted into evidence as Mr. Williams number 4. And you were asked some questions about this exhibit on redirect examination by the Honorable Miss Love, and I'll show it to you. Okay?
Yes.
Well, with Mr. Kokomo's permission. You can't see it, Mr. Kokomo, if you could bring it down a little bit. Okay, thank you, sir. You see at the top of Mr. Williams number 4, the page 1698?
Yes.
In blue?
Yes.
And from number 2 of Mr. Williams, 1603, that's approximately, I heard you say you're not good in math, I understand that, but it's approximately 95 pages of text between the two quotes, right?
Yes.
Okay, so this is a totally different day also. If you remember, and if you don't remember, we could go back to it. On Mr. Williams number 2, this is on February 4th of 2021, right? Mr. Williams number 2.
Yeah.
I could show it to you. Do you need to see it?
No.
Okay.
And going over?
It's the same thing, yes, sir. And then on Mr. Williams number 4, this is now on the very top of it is February 6, 2021, right?
Yeah.
Okay. And then, as the indictment says, the next line after on Mr. Williams number 7, we'll just start bringing me the money. You see that?
Yeah.
That's not until February 7th, what, about 100 pages later in the text messages, right? Or the chat messages, right?
Yeah.
Let me show it to you. Give me 1 second. I apologize. Tricia, what page? let me do this. On page 1706, if you don't mind, Mr. Kokomo, right in the center, just below center of that page, do you see at time 1:00:20? Mr. Kokomo, if you could wrap your, could circle it. Do you see that, Mr. Stevens?
Yes. Yes.
Okay, and that's on page 1706. Right? That's more than 100 pages in chat later, right?
Yeah.
Does that have anything to do, that quote right there, you'll start bringing me money, really, does that have anything to do with what the prosecutors put in overt act number 127 earlier about little Uzi Vert's?
Yeah, we didn't objection as to the point of the question. We did not have anything about Uzi Vert's.
I stand the objection.
There's part that is on the board, on your screen, you'll start bringing the money. If you go down a little more, Mr. Kokomo, bottom of that page, you see right there, man, y'all little ends, stop playing with me. You see that's the second to last one?
Yeah.
Do those items, those words have anything to do with little Uzi Vert's
Objection, Your Honor, again.
statement?
I stand the objection.
Does it have anything to do with what is written at the beginning, YSL ruled the world? Is there anything to do with it?
Them two different conversations.
Right. Objection to the commentary, right.
I stand it.
They're not even close in context. Context is a bad word. They're not even part of the same conversation, right?
No.
And Miss Love started to read sections skipping around in Mr. Williams' number 4 to you earlier today. You remember that?
Objection as to the compound nature of skipping around.
It's not a compound question.
I stand as the form question.
Do you remember the Honorable Miss Love asking you about Mr. Williams' number 4 and asking you about specific chats this morning? If you don't remember.
But she was right here reading with me.
Yeah.
Yeah.
You remember that?
Yeah.
And she was going out of sequence, right? With that, do you know what I'm?
Yeah, I know what you mean.
Okay.
I'm trying to remember what she reading like. Some she was reading directly right up on each other, and some she'll flip the page. So yeah.
Okay. Now, the chats that Mr. Williams is referring to that you were a part of in Mr. Williams' number 7 and the number 4, and the jurors will have this.
Objection, Your Honor.
It's in
I
evidence.
stand the question.
This is in evidence. Mr. Williams is commenting on the fact that you were trying to raise money for rent, right?
Yeah.
Okay. Where in this chat or in anything in Mr. Williams' number 2, is there anything criminal dealing with Mr. Williams?
I stand the question.
Where is there anything that furthers the interest of a RICO conspiracy in
I
Anu?
stand the question, Mr. Steele. Let's move on.
Now, Miss Love only asked you about Mr. Williams' number 4, the one we were just talking about. It's on the screen, right?
Yeah.
She didn't mention Mr. Williams' number 2 that I just showed you, right? Correct?
I think it was like 21 pages. That what she showed me.
She didn't ask you anything about Mr.
No.
Uzi Vert, correct?
No.
That's Mr. Williams' number 2 and 3. She didn't ask you about Mr. Williams' number 7 at all, right?
I'll rule the objection.
Am I correct?
Yes.
She didn't ask you anything about that. Okay. Now, Miss Love asked you over and over again about Mr. Williams talking about God, being humble, truly humble unto God. You remember any of those type of questions?
Objection, Your Honor, as to compound.
I stay in the question.
Do you remember questions about, that the prosecutor asked you about Mr. Williams being humble?
Yeah.
Do you remember questions that the prosecutor asked you about God? Mr. Williams talked about God.
Yeah.
Do you remember questions that the prosecutor asked you about truly humble under God? It's called an act, well, just truly humble under God, thug. You remember those questions?
Yeah.
And she limited you to a song that is in existence in the public domain. Do you remember that? She kept asking about songs.
Your Honor, I object as to the characterization.
I stay in the question.
Do you remember the prosecutor consistently saying, for you to remember what song mentions humble or God? Do you remember that? Or truly humble under God? You remember that?
That was my understanding, to remember a song that says something about God. To say a song that says something about God. And I choose that one because I remember that specific part in the beginning of the song where you were referring to God.
And you're talking about what's the meaning of life or whatever dropping jewels is?
Yes.
What Ms. Love didn't ask you about is whether Jeffrey ever gave any interviews, public interviews, about the meaning of did she?
Trying to get in self-serving.
I'm not asking about a statement.
Let him finish the question before I can rule on it. So what's your question, Mr. Steele?
Did Ms. Love ask you anything about Mr. Williams giving an interview or interviews in 2016, let's say, 8 years ago, about being humble and what it means that he doesn't want to be known as Young Thug? Did she ever ask you those questions?
Objection, compound.
I stay in this deform. Why don't you rephrase?
Okay. Did the prosecutor ask you any questions about Mr. Williams' statement, public statements about being humble?
Objection, Your Honor, as to
Basis.
any statements by the defendant would be self-serving, hearsay.
I stay in this.
I'm not asking a statement. I'm asking what Ms. Love asked that.
I stay in the question, though. Form of the question.
The judge doesn't want you to say what Mr. Williams said. Don't say what he said. Do you know of public interviews of Mr. Williams given concerning the topic of being humble?
Objection. One.
Basis.
It would be, again, he is attempting to refer to self-serving hearsay. It would be speculation as to what the defendant meant in the interview.
I'll stay in the question.
Do you know, without saying what Mr. Williams said, because the judge is sustaining that, do you know Mr. Williams explaining anything in interviews?
Objection, Your Honor, as to anything about.
That's the same question 3 times, Mr. Steele. So can you move on to something else?
Do you know whether Mr. Williams has ever discussed, don't tell me what he discussed, that he does not want to be known as Young Thug, but it's what makes money?
That's been asked and answered. I'll stay in the question.
Okay. Okay. You know the song Let Me Live by Mr. Williams?
Your Honor, I would object to any reference to statements by the defendant offered by the defendant.
I'll overrule the objection. Can you answer that, sir?
Trayvon Martin's song?
Objection, Your Honor, as to what the song is about.
Yeah.
Do you know that song?
He needs to finish it with, first maybe ask him if he knows the song.
Do you know that song?
I'm trying to think.
Take your time.
No.
If I played you the song in private, do you think that you can tell the court and the jury whether you recognize the song or not?
Yes.
Objection under 24-801.
I stay in the question.
Do you know whether Jeffrey Williams spends a tremendous amount of time when you're with him, when you speak with him on the phone, in a studio recording?
Yes.
Do you realize that Mr. Williams has thousands of songs that are not released?
Yes.
Do you realize that Mr. Williams has thousands of songs that have been stolen?
Objection, speculation.
If you know.
An objection basis before the answers.
I stay in this forum. Why don't you rephrase it?
Do you know whether Mr. Williams' art has been pirated or taken? If you know. If you don't know,
An
just say I don't know.
objection as to relevance as well.
I stand the question.
Point being is Mr. Williams has a lot more songs recorded than what's in the public domain. True?
Yes.
Thousands more, right?
Yeah.
And do you know that Jeffrey Williams has songs under Jeffrey and not Young Thug? Do you realize that?
Yeah.
And do you know that those songs don't sell very well?
Objection, speculation.
If you know.
I stand the question.
Are you aware of that?
I don't know about the sales for real.
Okay. All right. The prosecutor asked you about Sergio Kitchens. You know who I'm referring to?
Yeah.
Now, he is an world-renowned, if you know, known artist. True?
Yes.
And he goes by the stage name, what?
Gunna.
G-U-N-N-A.
Yes.
Okay. And the prosecutor asked you whether he was a co-defendant, and a co-defendant means it's a human being. Defendant's just a kind of strips a person, but it means it's charged with a crime, right? It's.
I stand the question.
You understand that it's the state of Georgia plaintiff versus Brian Steele defendant. I'd be the defendant. You understand that? That's where the word comes from? Okay.
Yeah.
And Mr. Kitchens is, in this indictment, an accused. You're aware of that?
Yes.
Okay, a defendant, right?
Yes.
Okay. And Mr. Kitchens, if you're aware, resolved his case. True?
Excuse me. Yes.
About a month before you did, right?
I don't remember. Was it a month?
That's fine. And he was released from jail, right?
Yes.
And he pled Alford, meaning he maintained innocence, right? This is,
I stand the question.
it's on the indictment.
I know, but I stand the question.
All right. Now, do you know what an Alford plea is?
Objection, Your Honor.
I stand the question.
I'm asking the witness if he knows.
I stand the question.
Okay. All right. Now, I want to talk with you about Gunna or Mr. Kitchens. The prosecution keeps calling you the leader or the beginner or the creator of YSL, one of them. You realize that?
Yes.
You and Jeffrey and a man named Walter Murphy known as DK, right?
Yeah.
That's what they're saying. And tell the jurors what crime that you know that Sergio Kitchens ever committed to further the interests of a criminal street gang YSL.
I object, and I'd ask.
Basis. Okay, all right, come on up. Tim, Mr. Stevens, please.
Sir.
Mr. Stevens, please.
Jeff. Okay. Okay, I need to talk to you about some other stuff they want you to do. About the prerequisite. Yeah,
Mr. Stevens, tell the ladies and gentlemen of the jury, based upon your own personal knowledge, whether Mr. Kitchens or Gunna ever committed a crime to promote YSL.
Objection, Your Honor, compound.
Tell the ladies and gentlemen of the jury whether Mr. Kitchens ever committed a crime to promote the gang YSL.
Your Honor, he asked the exact same question, so this is still a compound question, so my objection. There are two questions.
I sustain the question.
What did Mr. I'm sorry.
Go ahead, sir. I'm sorry.
What did Mr. Kitchens do, if anything, to benefit a criminal street gang YSL? Tell them.
Your Honor, I object on the grounds that I mentioned at the bench, and I also object on the basis that
I'll sustain this to the question. Mr. Steele, why don't you ask them one question to begin with, and then based upon that, if he answers anything, then we'll take it from there.
Do you know if Mr. Kitchens committing any crime to benefit your gang?
objection, Judge.
I'm asking a single question.
Judge, he's asking a compound question.
No, he's not. Not in this one. I'm gonna sustain the question. I mean, I will rule the question. Let him answer that in that last one.
And I'd ask for a basis for his knowledge.
Go ahead, Mr. Steve.
I don't have any knowledge.
All right. Okay.
Now, I want to talk with you about, and if the state can help me, if you are able. I believe that's 20 UB. Mr. Stevens, it'll come up on the screen when the Honorable Prosecutor puts it up, and I thank her for doing that very much.
Mr. Kearns, could you let us in?
I have, well, I believe it's 20 or 29, but we have
27.
Thank you, sir. And thank you, Miss. Thank you so much. Mr. Stevens, if I can go through this photograph with you and the letters at the bottom, if that's okay with you, okay?
Yes.
Okay. First of all, do you recall where this photograph was taken, best to your memory?
No.
Okay. Is it fair to say, if you remember, this was what's called a posed photograph, meaning you know it's a camera is taking your picture, you're smiling towards the camera. Is that true?
Yes.
Okay. And behind you, it appears to be, I see 3 different vehicles. Is that what you see in the 20 states 27 UB?
Yeah.
Okay. And the far vehicle in the top left is a SUV. Is that fair to say?
Yes.
And then there's a vehicle next to that one, correct?
Yes.
And then you are seated in a chair right in front of a blue vehicle, right?
Yes.
Is that a Rolls Royce?
Yes.
And whose Rolls Royce is that?
Mr. Williams?
And did he give that to you?
No.
Okay. Now, you are seated, and if you can blow it up if you don't mind when you get a chance, maybe on the neck area of Mr. Stevens. Mr. Stevens, you see the Honorable Prosecutor blowing this up for you?
Yes.
All right, and I'm focused on, it looks to me like there's 2 chains. Is that fair to say?
Yes.
And one of them is a traditional, very strong, powerful cross. Is that right?
Yes.
Did Mr. Williams give you that cross?
No.
Did Mr. Williams give you the chain that cross is on?
No.
How about the next? You have something that I believe says a name. Is that right?
Yes.
What name is that?
My slug.
Okay. And did Mr. Williams give you that jewel?
No.
And did he give you the chain?
No.
Okay. Then, if you don't mind, if you can scroll in on the left hand. That's fine. I appreciate it. Do you see what the Honorable Prosecutor tried to get enlarged as much as possible? Your left wrist?
Yes.
And that is a Rolex watch, correct?
Yes.
And it's worth approximately $5,000?
Yes.
And that was given to you by Mr. Williams?
Yes.
As a gift?
A birthday gift.
Birthday gift?
Yeah.
Okay. Did you do anything for Mr. Williams to promote some sort of criminal activity in exchange for that birthday gift?
No.
Did Mr. Williams give it to you and then tell you, I'm ordering you to go commit this crime on behalf of YSL? Did that happen?
I sustain the question.
Did Mr. Williams give that to you with any type of strings attached? That may be a bad way to say it.
Objection.
Did you do
I sustain this to form. Go
Did
ahead.
you do anything for Mr. Williams in exchange for that gift?
Gave it to him because I was born on my birthday.
Because of a birthday present.
Right.
All right. Now, if you can go to the right wrist, do you see that I believe you're wearing what I'd call a chain on that right wrist? Do you see that? And if I'm wrong, just say I'm wrong.
You wrong?
Okay, that's just part of the fabric?
It's not. That's not jewelry.
Not jewelry. Okay. Nothing to do with Mr. Williams?
No.
Okay. Then if we can go up a little bit. Actually, down a little bit. And you see that writing?
Yes.
Okay. And this was in the first line that there's words. This was liked by IAM_little git and 1,181 others, right?
Yeah.
And this on Instagram. Is that fair to say?
Yeah.
Okay. And then what you wrote is _1slug, bust down Rolly, came from Thug, meaning Mr. Williams, right?
Yes.
You know it's real.
Yeah.
Real or real love or whatever Little Baby said, right?
Yeah.
And what does that mean, whatever? Well, who is Little Baby?
Entertainer.
Okay. Is he a musical entertainer?
Yes.
And people would say a rap entertainer? Gangster rap?
Entertainer.
Okay.
Like, he do a lot of stuff.
And what does it mean, if you remember, what did you mean by whatever Little Baby said?
I think that was one of his lyrics in his song.
Okay. That's a song, right?
Yes.
Okay. Is there anything in State's Exhibit number, and they said 27, you, Little B is in Barry or Bravo, anything in there that's connected to somehow a criminal conspiracy RICO count?
Objection, Your Honor. That is a matter for a jury.
He's right here.
Good question.
Did you post this in any way that is criminal activity?
Your Honor, objection as to the same
This is his posting.
Jury is tasked.
I'll rule the objection. Can you answer the question?
Is this in any way affiliated with criminal activity?
Your Honor, that objection, because that is a matter that we will argue in the court.
I'll sustain the question.
Is State's Exhibit number 27 UB have anything to do with a crime and Jeffrey Williams?
Mr. Steele, I've sustained the objection. Please don't ask it again, please.
Now, the prosecutor asked you today that after Jeffrey became famous, you went separate ways. You remember something like that?
My bad. Yeah, she had me a lot of questions. My bad.
Actually, Jeffrey spent a lot of time working, didn't he? Before he became famous.
Yes.
And prosecutor asked you, why didn't you spend that much time? You already explained that to the jury, right? Basis.
Arguing or asking a question he wasn't at. I didn't ask that. Misrepresenting.
Oh, the objection. Can you answer the question?
You didn't.
Yeah, I answered. I told her I didn't have no talent.
And that's very, modest of you. Modest means polite of you to say you didn't have the talent, but you also didn't put in the time with Jeffrey, right?
No, I ain't putting no time.
You were doing other things while he was working, right?
Yes.
That's what you said earlier on your cross-examination, right?
Yeah.
Nothing about when Jeffrey became famous. That's how Jeffrey, he went for something, right?
Yeah.
You told the jury it was amazing. It was your word.
Your Honor, I'm going to object if he's already
Basis.
asked and answered.
I sustain the question.
All right. State's exhibit number 16U. It might be in front of you. Is that what the number is, if you don't mind helping me out, Mr. Stevens?
Yes.
Now, you were answering all the questions asked by the Honorable District Attorney Hilton. Remember that?
Yeah.
And you were put under oath, right?
Yes.
And the Honorable Judge Glanville, Chief Judge Glanville, he was here asking you questions as well. He was present, right?
Yes.
Where in that document or in the video does it ever say that Jeffrey Williams was part of a criminal street gang? Tell the jurors.
It don't.
I'm sorry?
It don't.
So you were under oath, having to answer all the questions of the prosecutor, and they didn't ask you that question.
Ain't in there. No. I ain't get asked that.
I can't hear you.
I didn't get asked that question.
Was Jeffrey Williams part of any criminal street gang whatsoever, sir? To your knowledge, as charged in YSL, RICO count, or any other gang activity
Objection,
here?
Your Honor. Compound.
I sustain the questions to form.
You were asked about YSL, and the prosecutor, Love, asked you, are there Crips in YSL? You remember that?
Yes.
And are there Bloods in YSL? She asked you. Remember that?
She had me a lot of questions. Huh?
That's fine. If you don't remember, it's fine. Or maybe I'm wrong. Okay. I want to talk to you about Jeffrey Williams' YSL. Okay?
Yeah.
Young Slime Life. That's a record label. You know that, right?
Yes.
And are you familiar? And if you're not, just say, Brian, I don't know. Okay? Does YSL produce music?
Yes.
Does YSL record label distribute music for public consumption? Consumption means for the public to listen to.
Yes.
Does YSL include music engineers?
Yes.
Does YSL include lawyers? Business lawyers?
Yes.
Does YSL have managers?
Yes.
Do they have bookkeepers? That means people who keep all the money.
I mean, they got to it. That's a business.
If you don't know,
Yeah. I don't.
okay. Do you know if YSL pays taxes?
Yeah.
Do you know whether they're registered company in the state of Georgia?
Yes.
Do you know whether they were bought out by a publicly internationally traded company?
Your Honor, I asked for a basis. I object as to
Do you know that?
basis for his knowledge.
It's public information if he knows.
I sustain the question. It's been asked and answered too, Mr. Steele.
Do you know whether this record label that Jeffrey created, if he's a part of it?
Yes.
And are there people who do promotion and advertising
Yes.
and search for new artists, A&R,
Yes.
and people who promote interest in Young Thug brand?
Yes.
And Young Thug brand is something that you don't back down, no fear. That's what was created, right?
Objection as to speculation.
If you know.
I sustain the question.
In the public domain, that's what Young Thug brand is, right?
Objection again, that same basic
I sustain the
speculation.
question.
Okay. I would like Mr. Kokomo, with his permission and the court's permission, to show privately Mr. Stevens that song, Let Me Live, to see if he knows the song, Your Honor.
Your Honor, I object.
I sustain the question.
Okay. Did Jeffrey ever give you anything in order to enable the stature or the respect or the benefit of any gang?
Objection, Your Honor.
Did he ever give you anything?
I sustain. Mr. Steele, it's getting to the point, it's asked and answered at this point as well.
Now, in Mr. Williams number 4, the chat that's in evidence,
Yeah.
there were talk about, and if you need to see it, we can put it up and hand it to you, okay? There was talk about Mr. Williams saying, I'm on this thread. Don't play with me. I'm a real gangster, for real. Don't talk like that behind my back because I'm here. You remember all those conversations? And Mr. Williams said, I pay for everything. Remember all that?
Yeah.
Does Mr. Williams pay for the $1,500 rent that you were trying to raise?
No.
And when Mr. Williams wrote, he pays for everything, if you go out with him, he'll pay for you, right? At a club.
Yes.
True? At the studio. Dinner. Drinks, right?
Yes.
Is Mr. Williams funding criminal activity that you're aware of?
Objection.
I sustain the question.
He would know.
Sustain the question.
Okay. Your Honor, may I have just a second?
You may, sir.
Your Honor, is Odyssey up? Because I was told.
Sir, it's not.
Do you have the dates?
We cannot access ours. And I have no.
Mr. Stevens, the prosecutor was asking you whether I visited you in a jail. Remember those questions?
Yes.
I asked them for the dates.
Objection, Your Honor, as to Mr. Steele talking about anything, conversation outside of Mr. Stevens' presence in his direct or cross of Mr. Stevens.
What's the basis for your objection, madam?
Improper question.
I sustain the question.
No date was given.
Objection, Your Honor, he's testifying.
I sustain the question.
Have I ever represented you on anything?
No.
Do we have any type of relationship, attorney-client-wise?
No.
Do you know that I've defended Jeffrey in other cases for 8 to 10 years?
Yes.
Do you know that Jeffrey's put my name in songs?
Yes.
Do you know whether you called me because you know I'm a lawyer in Atlanta?
Yes.
Did that have anything to do with Jeffrey Williams?
No, I was just trying to get somebody to represent me for my probation revocation.
Except for those other items, I don't have anything else.
Okay. State anything further?
No, Your Honor, no further questions.
All right. Anybody else? All right. May we excuse Mr. Stevens permanently or temporarily?
Permanently for the state's interest.
All right.
Your Honor,
Sir?
now hold him temporarily based upon the Odyssey and that other matter you told, where you said go. So I don't want to do it. But he's free to go. I'm not going to hold him.
Can you all approach for a second, please? Mr. Stevens, just don't go anywhere quite yet. You go ahead. Mr. Stevens, please. Okay, Mr. Stevens, thank you for your patience with us. We're going to temporarily excuse you as a witness. That means you'll be subject to recall. So I'm going to excuse you at this point in time, but I'm also going to just ask that you not discuss your testimony with anybody except the attorneys in this case. If we need you, we have a number for you. Is that correct, Ms. Gladden?
Okay, sure.
Okay, so we'll give you plenty of heads up, so if we need to recall you, we'll go ahead and do so at that time, okay? But thank you for your patience with us, all right?
All right.
All right, thank you, sir. All right, ladies and gentlemen, how about we take a afternoon stretch break, about 15 minutes? You okay with that? Unless you just want to drive on right now, okay? All right. Okay, ladies and gentlemen, let me go ahead and let you take a comfort break, stretch break. We'll do the same, and then I'll let you know where we're going to head the rest of the day, okay? All right. All rise. us a ballpark length of what you're talking about? Just so I can determine, make some decisions?
I'm going to let Mr. Smith address that as he is. I'm sorry. Yes, I'm going to let Mr. Smith address the court as those are his witnesses.
Yes, Your Honor. With the first witness, I think it'll be about 30 minutes, 20, 30 minutes. And the second witness.
Who's the first witness?
First witness would be Officer Reed, as we transition to Act 61.
Okay. And if we decide we want to take anything more than that, who's after that?
Officer, Mr. Floyd, Officer Floyd, related to the same act.
Okay.
Officer Floyd, with the same act.
Okay. All right. Same length of time?
Approximately.
Okay. All right. Let's just plan on taking one witness, and then you can excuse the other one until tomorrow.
Okay.
Okay.
And what time would you like?
I'm going to check right now, sir.
Yeah.
Let's do 9 o'clock for a 9:30 start time, okay? All right, okay. We'll be in recess 15 minutes, all right, folks? All right. We're in recess? All right, Sergeant Ingram, everybody here?
Yes, sir. Everybody's present and accounted for.
Okay, councils, we're going to take this one last witness and then we'll be done for the day. Anything I need to take out before we call a witness? What's the name of the witness?
Officer Nicholas Reed, Your Honor.
All right. Summarize jurors, please. All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. All right, ladies and gentlemen, the jury, we're going to call one more witness and for the day with your concurrence, if that's okay. All right, state, call your next witness, Mr. Smith.
Your Honor, state calls Officer Nicholas Reed.
All right, Officer Reed, come on up to the witness stand here. Before you sit down, if you'd be so kind to turn and face Sergeant Ingram, be sworn as witness before you stand up, before you sit down. Okay, all right, there you go.
Raise your right hand. This is our firm testimony you give today. The truth, the whole truth, nothing but the truth. I do. That's it. State your spell, the first and last name for the court.
Nicholas Reed, Nicholasreed. Who's that?
Officer Reed, good morning, or good afternoon, sir.
Afternoon.
Sir, can you speak up?
Good afternoon.
Thank you. So where do you currently work?
I currently work for a company called Arbonomics.
Okay. And what do you do for Arbonomics?
Just make grass look pretty.
Where did you work previously?
I used to be over at the solicitor's office and APD before that.
And how long were you with the solicitor's office?
For about a year.
How long were you with APD?
About 6 years, 5, 6 years.
If you can recall, what years did you work for APD?
2013 to about the end of 2018.
And what units were you assigned to while with APD?
I started out in Zone 3 and then worked over to the Apex unit and then Zone 4 after that.
So what years were you with Zone 3?
Zone 3 from 2013 to about 2015.
And what years were you with Zone 4?
2017 to 2018.
And what years were you with the Apex unit?
From about 2015 to 2017.
And what is the Apex unit?
Basically, it's a proactive policing unit. Go out, try and find violent repeat offenders or major drug cases.
Officer Reed, what were some of your responsibilities as a Zone 3 officer?
Just patrol, enforce the law, respond to 911 calls.
And what area does that cover? What does Zone 3 cover that you patrol?
Which area did I cover?
Yeah, for Zone 3 officer.
For me, my particular area was up around Metropolitan, up toward Cleveland, down Sylvan, everything in between there.
And during your time as Zone 3 officer, were you post-certified?
Yes.
I want to turn your attention to May 11, 2016. Did you respond to a call at 245 Mall Drive?
I did.
Is that location in Fulton County?
Yes.
And were you in uniform?
Yes.
Were you wearing body cam?
No.
Why not?
They weren't issued.
What was the nature of the call that you responded to?
It was a carjacking.
Tell the jury what happened once you arrived on scene.
So basically, the call that I got was a carjacking. A female had a weapon put in her face, a gun pointed in her face, and the suspect drove off with a vehicle and a purse.
Officer Reed, I'm showing you what's been marked as States Exhibit 29B. Do you recognize that?
Yes.
How do you recognize it?
That's the victim of the carjacking.
Okay. Is that a fair and accurate representation of the victim that you met with on that day?
Yes.
Your Honor, at this time, the state tenders States 29B for admission.
Any objection?
Your Honor, I think I do have an objection, but I'd like to see that first, if I may. B, Baker.
I do object. I object on the basis that it goes to identity. Identity is not an issue, especially not for a witness who's expected to testify.
Can I see it, please? All right, here you go. Any further objections, sir? No. Okay, I'll rule the objection. States 29B will be admitted over your objection.
Thank you, Your Honor. Permission to publish?
Maybe publish as you see fit.
Mr. Reed, tell the jury who the photo is?
This is Miss Taravia Hill.
And you met with Ms. Hill on May 11, 2016, so you responded to the carjack?
I did.
Where was Ms. Hill located when you met with her?
The location was a condominium. Condominium. So there's a parking lot. She was outside in the parking lot when I pulled up.
Could you speak up just a little bit further?
The location was a condo. So when I pulled up, she was outside in the parking lot.
What was her demeanor like?
She was really frantic. You could tell highly upset. Something bad happened before I got there.
Was anyone with her?
Her daughter.
What was her demeanor like?
She was shook up as well. She was a little girl.
Did you ask Ms. Hill to write a statement about what happened?
I did.
And at some point, does Ms. Hill give you the tag information to that vehicle that was stolen?
She did.
What did you do with that tag information?
Immediately got on the radio and be on the lookout for all the officers in the zone to know what type of vehicle to look out for that was carjacked. And right after I put the bolo out, I was getting ready to get on the system and have the system added as stolen. However, another officer ended up saying that he had eyes on the vehicle before I could put it on the system as stolen, so there's no point in even going through with that part of it.
You went kind of fast, so why did you put the car in as stolen?
Because another officer already said he had eyes on it.
What was the bolo that you put out?
It's a black and colored Toyota Corolla.
And at some point, you learned that the vehicle was involved in an accident, correct?
Yes,
All right. Did you go to the scene of the accident?
I did.
All right. Once you arrived at the scene, did you see Ms. Hill's car involved in an accident?
I did.
And where was that location?
It was at the intersection of Cleveland Avenue and Macon Drive.
Did you take Ms. Hill to the scene of the accident?
I did.
Why?
After one of the other officers stated that they were behind the vehicle and the vehicle wrecked out, the suspect was was detained. So I put Mrs. Hill in the back of my vehicle. We drove out there, parked in the area where nobody could see us, at least where the suspect couldn't see us, and allow her to ID if the person that was detained was the correct person.
And was Ms. Hill able to make an identification?
Yes.
And who did she identify?
Mr. Eppinger.
I am now showing you what's been pre-marked as States Exhibit 18, V as in Victor. Recognize that photo?
Yes.
All showing you what's been pre-marked that states 32B is in Victor. You recognize that photo?
I do.
How do you recognize it?
That's the person that I ended up taking in custody.
Is that a fair record of representation of the suspect you took in custody that day?
Yes.
All right. Your Honor, at this time, the state's tender states 32B and 18B. Victor? Ayes have it.
Any objection to states 18 Victor or 32?
One more time, please, if I can just take a look, please.
Hold on.
I have a moment, Judge.
All right, states 18 and 32 Victor are both admitted and may be published as you see fit.
I asked if I could have a moment, Judge.
Oh, I'm sorry. I thought you said you had no objection. I apologize.
I'm going to object.
Basis.
To the admission of these photos on the fact that there's
Let's start out with 18 Victor.
18 Victor, and the objections are going to be the same for both 18 Victor and 32 Victor. Yes, sir.
Thank you.
May I?
Yes. Okay, all right, go ahead.
Objections been made previously that there's no nexus as to this particular individual and this indictment, so I would pose the same objection at this point.
All right, anything else?
That is my objection, sir.
All right, your objection is overruled. 18 Victor and 32 Victor may be admitted and published as you see fit.
Commissioner Bubba.
Oh, here you go, I'm sorry.
Mr. Reed, what are we looking at in this photo?
It's going to be a photo of the Mr. Eppinger. That's what I had in custody that day.
And is that Mr. Eppinger on the day May 11, 2016?
Yes, sir.
And is that Mr. Eppinger who Ms. Hill identified?
Yes, sir.
Now, was Ms. Hill inside or outside your vehicle when she identified Mr. Eppinger?
Inside.
Approximately, what was the distance between Ms. Hill, your vehicle, and the suspect?
Probably about 4 patrol cars, and then the distance of just crossing the street. So
If you can recall, what was the weather like that day?
it was clear. Sunny.
Did the suspect see Ms. Hill?
No.
I'll sustain the objection.
What did you do after Ms. Hill made the ID?
I took Miss Hill over to our mini precinct over near the amphitheater, and that's why I got in touch with the zone investigator, and he interviewed Miss Hill about the carjacking.
And just speak it to the mic.
I took Miss Hill over to the mini precinct and let her get interviewed by the zone investigator.
Do you remember what the suspect was wearing that day?
I just remember he had a jean jacket, that's it.
So, while in custody at the mini precinct, do you remember any statements the defendant may have made, Mr. Eppinger may have made in your presence?
No. At that point, I basically just took warrants out, and I know another officer brought Mr. Eppinger from the crime scene, or from the accident scene, over to the Mini, and then once they got there and I was done with my part of the paperwork and doing the as far as getting the warrants and everything typed up, I took them over to the youth detention center and pretty much was just there until they were ready to take custody of him. I don't know how that whole process works, but I just know it took a very long time.
So why did you take him to the youth detention center?
He was a minor at the time.
Can you read that one more time?
He was a minor.
I stand the question.
Do you remember when you cleared the actual this carjacking incident?
It was like early the following morning.
Why the next morning?
I was just waiting for YDC to take custody of him.
Court's indulgence, Your Honor.
Yes, sir.
Officer Reed, you spoke of another officer during testimony. What was that officer's name?
Officer Floyd.
And Officer Floyd had eyes on the car?
He did.
You spoke of a little girl in this heel. You know the approximate age of this girl?
Young, 5, 6, 7.
How far was the victim's house from where the suspect was caught?
Say again?
How far was the victim, Ms. Hill's house, or the location that you responded to? How far was that house from where the suspect was apprehended?
Probably about 6, 7 miles. Maybe. From a mall drive to Cleveland and Macon.
How old was the suspect at the time of his arrest?
The suspect?
Yeah.
I'm not sure. I don't remember.
But he was a minor?
Yes.
Officer Reed, what does the letters Y and C stand for?
Youth Detention Center.
Right now, I am publishing 32 V as in Victor. And what are we looking at here, Mr. Reed?
That's Mr. Eppinger.
And is that a fair and accurate representation of Mr. Eppinger on the date that you transferred him?
Yes, sir.
No further questions at this time, Your Honor.
Cross. Go ahead, Mr. Adams.
Thank you, Judge.
Mr. Reed, good afternoon, sir.
Good afternoon.
All right. You and I have not met prior to today, right?
No.
I think we did have a chance to chat briefly outside in the hallway. Is that right?
That's it.
All right. You were with APD, if I heard you correctly, from 2013 to 2018. Is that about right?
Yes.
Okay. You were assigned to Zone 3 between 2013 and 2015.
Yes.
This incident that you've been brought in to testify about occurred in May 11th, if I'm correct, of 2000 and, is that 16 or 15?
Say again.
When did this incident occur?
16.
Okay. May 11th?
From what it says on the paper, on the report, that's what I know.
Sounds about right. You've not been a law enforcement officer since 2018, is that right?
No.
Okay. And so in terms of coming in here to testify today, you've had to refresh your recollection based on your report or the reports that were written back in 2016, right?
Mm-hmm.
Yes?
Yes.
Okay, you got to say yes or no so the court reporter can pick it up.
Yes.
All right, there you go. That's good. Did you write a report yourself, or was it written by other officers?
I wrote my portion of it, yes.
Okay, and then Officer, what's his name, Floyd, wrote the other report?
Yes.
There would have been a CAD report, a 911 printout, that sort of thing?
It should be. I mean, we just do the narrative and, you know, just update whatever information we need to do. But as far as the CAD, I think that's something that the dispatch or another part will handle, communications.
Okay. You did take out the warrants, though?
Yes.
Okay. And those would have been several warrants taken out by you that would have had a little blurb about what the person is charged with, the basis for the charge, and the date, and your signature, that sort of thing. And the judge's signature.
Yes.
Okay. Now, so in coming in here today, I think I heard you say, correct me if I'm wrong, that you had a chance to review the reports from back in 2016, right? Okay. You knew then that you were coming in to testify in this trial. Did you know how it was laid out in the indictment, the exact charge, and who you were testifying about? Did you know that?
I knew who I was testifying about, and I knew I was coming to testify in regards to a carjacking, yes.
Right. A carjacking and you knew it to be, at least in the indictment, a part of some supposed racketeering or RICO charge, right? You knew that?
No.
You did not?
I know what this trial is about, but again, I'm just here to speak on just the carjacking and Mr. Eppinger. That's it.
The only thing it's in, again, correct me if I'm wrong, the only thing that you know, right, in totality is that there was a carjacking, right? You responded and you were involved in the investigation of that carjacking, right? And the person, Christian Eppinger, was ultimately charged with that carjacking.
Yes.
And he was the only person charged.
But he was the only one I had in custody, yes.
Okay, he was the only one caught, right? So what you know is that May 11th, sometime in the afternoon, you respond, you speak to Taravia Hill. That's the, you gotta say yeah.
Say again? You
gotta say yes or no.
Yes.
Okay, it's for the court reporter. Yeah. And let's see, where are those pictures that we, here we go. And picture of this hill. Here we go. All right. Ms. Hill, this picture that was shown a little earlier, that's the lady who you responded, who you spoke to, is that right?
Yes.
She was the subject of the carjacking. She's the person who was essentially assaulted by that person with a gun, right? Her and her daughter.
Yes.
And she called the police. Either she or her neighbor called the police, right?
Yes.
And you responded. You spoke to her, and another officer actually is the one who made contact with the vehicle that had been taken from Ms. Hill.
Yes.
Okay. This was a carjacking, right? You didn't know anything about the case other than that.
Objection, Your Honor. Ask an answer.
I'm allowed to finish the question first. Go ahead.
You didn't know anything about the individual, right? Other than this person had carjacked a woman, right?
Right.
Okay. So you respond. Officer Floyd gets behind and ultimately arrests the person, Christian Eppinger, right?
Yes.
There were no other people arrested in the vehicle that he was in, the stolen vehicle, right?
No.
In fact, there were no other people arrested.
No.
Right? Did you say that you're the one who actually took custody of Mr. Eppinger, Christian Eppinger, and took him to the precinct? Or took him to YDC?
I took him to YDC.
Okay. Now, you said he was wearing a blue jean jacket? Is that what you said?
A jean jacket of some sort. That's all I remember.
Okay. You remember the color of his pants or anything like that?
No, sir.
No bandana, no scarf, no anything hanging out of his pocket, nothing like that?
No, sir.
Just some kid who had just done a carjacking with a blue jean jacket and a pair of pants on and shoes, presumably.
I mean, if you're asking me to try to remember something from 9 years ago, most I can remember is that jean jacket, and that's it.
Okay. All right. So, at the time that he was arrested and taken into custody, I think you went to the location, right, where he was actually in custody. You took Miss Hill over there.
Yes.
Okay. Miss Hill identified, she said, that's the guy who carjacked me, right?
Yes.
All right. Now, you don't have any personal knowledge that this person, Christian Eppinger, was doing anything in furtherance of any sort of conspiracy.
Objection,
do you?
Your Honor.
What is the objection, please?
Speculation.
I stand the question.
Well, I'm asking if he has any personal knowledge, Judge.
All right, I'll allow that.
All right. Do you have any personal knowledge that this Christian Eppinger guy was doing this carjacking in furtherance of any sort of conspiracy?
No, sir.
All right. What you know is that you got a young man, whatever, who comes in, does a carjacking, he gets arrested, and he's taken to YDC, right?
Yes, sir.
And although you asked to, you identified this picture, these pictures of him, that's how he looked on that day, right?
Yes, sir.
Was he interviewed, and I don't want you to say what anyone said, but was there a detective who came to see Mr. Eppinger? Do you know?
Not that I can remember, no, sir.
Okay. You didn't have any conversation with him?
Nothing one-on-one. I mean,
okay.
No, sir.
You were asked earlier about the distance from where the incident occurred, right, to where he was ultimately arrested. I think you said 6 to 7 miles. Is that about right?
Yes.
Right. Now, it would be fair to say, and I'm asking you now to kind of base your answer to this question on your experience as a police officer, that carjackings occur all over the city of Atlanta, right?
Yes.
I mean, this was on Amal Drive, but there are carjackings that occur in Buckhead, in Southwest Atlanta, in Alpharetta. All over the city, a carjacking can occur, right?
Yes.
Right. There is nothing. Strike that. Let me ask that a different way. There's nothing to suggest, in this case, I'm just asking what you know about this case, nothing to suggest that this was a carjacking that couldn't have taken place.
Objection, Your Honor. Improper questioning.
I stand the objection.
All right, well, it happened on a mall drive, but it could have happened anywhere, right?
Yes, sir.
All right. This kid, Christian Eppinger, he's not in this courtroom. You don't see him, right?
No.
All right. Send pictures from back then. You don't see this kid. These pictures that they're showing, you don't see this kid anywhere sitting in the courtroom, do you?
Objection, Your Honor. Ask and answer.
I stand the question.
All right. You don't have any personal knowledge that this carjacking that occurred back on May 11th of 2016 had any connection whatsoever with Jeffrey Williams, do you?
No, sir.
You don't have any personal knowledge that this carjacking that occurred back on May 11th of 2016 had anything to do with anybody else in this courtroom, do you?
No, sir.
When he was arrested, you took out the warrants, right? And you took out a warrant for hijacking a motor vehicle, right?
Yes, sir.
Took out a warrant for fleeing, attempting to elude.
Yes, sir.
What you did not take out was a warrant for any sort of violation of the Anti-Gang or Terrorism Act. No gang charges. You didn't take out any gang charges, right?
No, sir.
And that is because you saw no basis to take out that charge, correct?
Correct.
I mean, this is 2016. You'd been an officer for 3 years at that point. You worked in Zone 3. You knew what a gang-related act or gang-related crime is, right?
Yes, sir.
Because, you know, you got to make notations of what you think is actually going on in a particular circumstance, right?
Yes, sir.
And you could have done that, but you did not, right?
I didn't see any reason.
I'm sorry, say that again.
Say again?
I didn't hear you.
Oh, I didn't see any reason for anything like that.
There was nothing about this kid, no matter how he looked, or the evidence, or the statement, or anything in your investigation that led you to think, hey, this has something to do with some kind of gang, right?
No, sir.
2016, we're in 2024. So a little under 8 years ago is when this incident occurred, right? Yes?
Yes.
Since then, did you have to go to court in regards to this case?
Just today.
Just today?
Yes, sir.
From 2016 to today? First time you've shown up in a court to answer any questions about this or been called?
As far as I can remember.
Okay, all right. It's the first time DA's office ever contacted you and said, hey, we need you to come in and talk about this case from back in 2016, right?
As far as I know.
Brother Vince?
I'll allow it.
All right. He's answered. That's all I have.
Okay.
All right. Redirect on it.
Hold on. Anybody else have any questions? All right. Yeah. You have redirect now?
Yes, briefly. Officer Reed, were you trained to investigate gang activity?
Say again?
Are you trained to investigate gang activity?
Gang activity?
Are you trained to investigate?
No, I haven't gotten any training on that.
Now I'm publishing 18B. Are you able to make out any marks on Mr. Epinger's face?
I mean, I see a mark, but I can't.
I'll sustain the objection.
Do you see anything on his face?
I sustain the
see
objection.
a mark on his face right
Hold
now.
on, hold on. I sustain the objection. Ask something else.
Officer Reed, was Mr. Eppinger the only person reportedly involved in this carjacking?
According to witnesses, there was another car that had other individuals in it that followed the black Toyota, but they must have went opposite direction because, like I said, the only thing
Hold up. I sustain the objection. It's speculation by Mr. Matthews, and I believe Ms. Westmoreland, but her grounds were not determinable. But anyways, I'll sustain the objection.
Officer Reed, how many people were you on the lookout for after talking to Ms. Hill?
One in particular, Mr. Eppinger, because that's the one that I had all my attention drawn toward from what the victim was telling me. As far as who took the vehicle, like yes, she said there were other people in the vehicles, in a second vehicle, but like I said, we're more concerned about trying to get the actual person inside the Toyota.
And were you also looking for another car besides Ms. Hill's vehicle?
There was a tan and color car. That's all I can remember about that one.
Do you know any more about Mr. Epinger's accomplices?
No.
Nothing further.
Anything further, Mr. Adams?
Yes, sir.
Thank you, Judge. Just, I'll say one or two more questions, but I don't want to be held to that. So just a few questions.
Well, I'm gonna hold you to it.
Well, so 4 or 5 questions.
So, okay, that's 5. I'll give you 5. Okay. That's the upper limit. Come on now.
Number 1. All right. You had information about other people in the car that this kid Eppinger got out of, right?
Yes, sir.
All right. Those other individuals were never apprehended. No one else was apprehended other than Mr. Eppinger, right?
As far as that day, that's all I know, Mr. Eppinger.
Okay. It is impossible to say what, if any, role those people in that car had in this carjacking, right?
I don't know.
It is impossible to say who those people in that car were, right?
I don't have any idea.
Okay. And you're not aware of there ever being any arrest of anyone else for this incident, this carjacking from May 11th of 2016, other than Christian Eppinger, right?
No.
All right. Was that 4? Okay. Thank you. That's all.
Thank you, Mr. Adams. Anybody else? Okay. Anything further, sir?
No, Your Honor.
All right. All right. May Officer or Mr. Reed be permanently or temporarily excused as a witness?
Permanently, Your Honor.
All right, hearing no objection. Mr. Reed, thank you for your patience with us. We're going to permanently excuse you as a witness. Just don't discuss your testimony with anybody but the attorneys in this case. You're free to go about your usual duties and avocation, okay?
Thank you.
So thanks to the court and the parties. Okay, ladies and gentlemen, as promised, the hour is about 5:15. How about we go ahead and recess for the day? All right, ladies and gentlemen, we're going to convene tomorrow morning for 09 with an anticipated 09:30 start time. So if you could please vary your routes and be here as you have so we can go ahead and get started. We'll try and get started as soon thereafter as everyone's present and accounted for. Just remember, let's go through our admonitions. Now you've heard testimony. Are you allowed to talk about it amongst yourselves? No. Are you able to talk with your friends and neighbors about it? How about doing any research? How about go visit the scenes? How about listening to the news media? How about let third parties talk to you about it? Friend people on Facebook. All right, okay, I think you understand the point. Ladies and gentlemen, thank you for your continued vigilance to the court's ad nauseum admonitions. As we stated to you earlier, those are the reasons why both parties a fair trial. So continue to do that. And remember, if anybody should attempt to talk with you in any way about in any violation of the court's admonitions, you let me as well as Sergeant Ingram know immediately. Okay? All right. Remember to leave your notepads in the basket in the back. Are you all okay with notepads? Yes. Okay. All right. Has anybody gone to a second notepad as of yet? Okay. Go ahead and write your name on the inside of the second cover or whatever number it is for you, and just make sure you keep those together, and we can give you some rubber band in order for you to do that. But how about juror stickers? We good on those? All right. Remember, Miss Omana will replace those if just let us know. Okay. All right. How are your headquarters in there? We good? In the back? All right. Okay. I'll let the landlord know. All right. Okay, ladies and gentlemen, any ministerial inquiry of me?
Do you still have those dates in mind? What's the pre-plan?
What's that? I'm sorry?
The dates. You were going to talk about that last.
Yeah, that's before things kind of happened from last week. So let me get, no, in all seriousness, I will go ahead and let you all know soon. Okay, we'll go tomorrow. What I'll do is I'll at least cover the rest of the week, okay, and or the next 2 weeks, I should say, and let you know what our plan is. But it seems like we'll kind of be, other than taking a few hours or half a day from there, but I'll have to check the schedule. So can we check on that? I'll give you an update tomorrow. Okay. All right. Anybody else?
When we have folks up here talking, you know, speak clearly into the microphone. It's kind of hard back here to hear.
I know, it's terrible, isn't it?
Like we whisper, and so in any way, form or fashion, we have them speak clearly into the microphone.
I will certainly ask them to do so. Okay. Anybody else? Okay, ladies and gentlemen, again, thank you for your untiring patience with us and the patience that you'll continue to give to us. I say that on behalf of all the parties assembled here. And ladies and gentlemen, unless you have any other inquiry of me, I'll go ahead and recess you until tomorrow morning at 9 o'clock for an anticipated 9:30 start time, and we'll go ahead and see where tomorrow leads us, okay? All right, we're in recess. All rise. on site.